Someone make it make sense.
I'll be a couple.
Hello, everybody. We're back for round 2 with some more Kohberger documents. I wasn't sure if I was going to be going live again, but for those of you guys who are members and who are interested in the orchid videos, I was working on the next orchid video for you guys dealing with pot size. And I was editing that and I was like, I need to take a break. So I was like, you know what, let's just go ahead and get some more of these documents out of the way since there's like 50 bazillion of them and it's going to take about 10 years. So we are back for more. So shout out to Kane, the rat daddy. How are the rats these days? Shout out to P Fox. Love y'all. Glad you guys are here. Awesome. Awesome. Hopefully you guys are doing well. Love to know what y'all think about these documents. So earlier we covered, God, what did we cover earlier? We covered the text messages, the, oh my God, now I can't even remember. There's so many of these documents. We covered, let me see here. Let me look at the thingy. The thingy. Okay, we covered, oh yeah, the people, the victims in the courtroom or whatever, the family in the courtroom. We covered the, oh yeah, the SIRE at the upcoming hearing. We covered ITG. And the text messages. Oh, and the demonstrative aid and the ATT timing advance records. I think that's all. We may have covered another one. That's what I think we covered. Looking at this. And it was very interesting to see those text messages. There was a lot of mind-blowing information that we went through already. We're back for more. Back for more. Yes, indeed. Chelsea, that is I. That is I. Haven't heard any of them yet. Interesting. Okay. Wow. Well, I will shortly here be able to start working on timestamps for the previous live stream. For those of you guys who will be on replay crew, it was very, very interesting. And I did save the document. We highlighted what was omitted from the state's filing, was missing from the state's filing. We highlighted that in the defense filing and I saved it that way. But also the defense left some things out. And so I added those and put them into the defense filing for the text messages they left out. So that way we can get a complete picture of who left what out of what. And yes. So hopefully one of these days we'll get we'll get it in its complete version, right? Because again, the defense is going with the rule of completeness. So we would hope that we can get complete record there. So I have no idea what that means. You love meat on the bone. You know, I'm vegan, right? So, okay. All right. So we're starting out here with this is the defendant's objection to the state's motion in limine, alibi. Woo! All right. So the state provided the court a list of pleadings to take notice in support of its motion. However, the state failed to provide the court with the full scope of the pleadings. Mr. Kohberger filed a response to the state's request for discovery disclosure and, let me zoom in a little bit more. There we go. And alibi demand on June 9th, 2023, and contemporaneously filed a motion for an exception or an alternative to extend time for compliance. Interesting. The state filed a response to our motion for an extension on June 13th, 2023 with an agreement for additional time. Mr. Kohberger filed his notice of alibi. Okay, so this is going through the history of this. And we talked about this with the state's filing, which is that like basically it kind of fizzled out, right? There was like the whole thing, like it was an alibi, not alibi. And then like nothing else was really ever said about that. Now, one thing I thought was especially interesting in two of the defense filings we covered earlier was that it was very clear. They said it many, many times. They used the phrase partial corroboration of the alibi. And what I thought was especially interesting about that was it seems intentional. And it made me wonder if they're almost signaling that the other part to complete the alibi, right? Part, because again, referencing partial corroboration, the rest to corroborate. I wonder if that is them signaling that he might take the stand, which kind of just blows my mind, right? Because we know it's usually not, I feel like most of the time, usually they're going to advise defendants not to take the stand, which they may very well be doing, right? But I think it goes hand in hand also with a huge change that we're going to see here in an upcoming document that we're going to cover tonight with the autism, because whereas initially it was just going to be used for the mitigation phase, it looks like now they want to use it for the entire trial. So that's big news. And a lot of what they're going to be talking about is so that the jury has an understanding for maybe certain mannerisms or behaviors or whatever. And that would make a lot more sense, especially if they expect him to take the stand to then add that the rest of the partial corroboration for the alibi, right? The partial corroboration that was referenced earlier that we were talking about was they were talking about the cell phone records. The cell phone records are partial corroboration. So the remainder is they haven't said, which is why I'm wondering if it's going to be testimony from the defendant. Crazy. So Heather's saying put him on the stand. All right, there we go. So well, welcome as well, Echoes of Clarity, joining us from Alabama. I do believe. I sometimes get Alabama and Arkansas confused, but I'm pretty sure it's Alabama. Eating Life cereal, cinnamon, yum. That's funny. I guess when Heather's kids missed the, what was it, blood worm moon. So yeah, so it looked at that. I'm wondering if that's the case. We'll see what else they say. I mean, this year, the reason I'm bringing it up, this is the alibi document now, so we're gonna learn more. So okay, so Mr. Kohberger. Okay, wait, hold on. Let me go back. All right, the Idaho Code governs the notice of alibi and requires specific names and places to verify where a defendant was at the time of the crime, in italics. Mr. Kohberger advised the state that he intended to offer expert testimony through Sire as, there it is again, speak of the devil, partial corroboration. Y'all, there it is again. Perfect. I'm glad I just gave it that little background. Partial corroboration, right? That he was driving south and west of Moscow, Idaho during the early morning hours of November 13th, 2022. The expert testimony involves CSLI. Mr. Kohberger further advised the state of his intention to cross-examine any state expert in that field. Right. After that disclosure, the court heard Mr. Kohberger's fourth motion to compel, wherein, among other things, Mr. Kohberger sought further records related to CSLI. Mr. Kohberger called Mr. Ray to testify at this hearing, and the state declined cross-examination. That's true. That happened. The state provided records necessary to CSLI in various batches of discovery. These records consist of call detail records from AT&T, cell tower lists, and drive test data. The state provided its cast draft report and later a final report. However, no analysis has been provided. The state did not provide or produce a timing advance report for Mr. Kohberger's cell phone, footnote 1. See also motion limine. Right. We covered those. And that was also very interesting about the timing advance and how that worked out. Okay. Partial corroboration. Again, partial corroboration does not cover the time alleged. Okay. So initially, before I had the thought about him taking the stand, the first thing I said in terms of this partial corroboration thing, as I noticed it kept coming up, I said, I wonder if they're saying partial corroboration because if they're just referencing that the 7 minutes, which is what they meant, they mentioned that in the other documents we covered earlier. I thought to myself, I wonder if it's because it's the 7 minutes up to like, what is it? Like, I think 1:54 a.m., but not at the actual time that the homicides potentially occurred, according to the state, like approximately 4 a.m. So it's like not at the exact time. So maybe that's where they're getting the part. That was my initial thought. Then I thought, I wonder if they're saying he's going to take the stand. Still could be true, but now they are saying here, it does not cover the time alleged in the state's charging documents or in any affidavits in support of searching and seizing Mr. Kohberger's person and property. Okay, partial corroboration relates to where Mr. Kohberger was during the early morning hours. Okay, so interesting. So maybe I don't know. We'll see. But this was my first thought, was that the partial corroboration could be because it's not at the exact time. So, okay. we'll keep reading. Keep reading. The state cites to State v. Juarez to suggest that Mr. Kohberger is hiding a witness that will prejudice the state. This is not the case. Mr. Kohberger has stated exactly how he will partially corroborate where he was. He will use information contained in the discovery supplied by the state, and he will present the testimony of expert witness Syria. Okay, so maybe not taking the stand. We'll table that thought for now. And maybe my initial thought was correct. Mr. Kohberger has met his statutory obligation. Is that, and then what else do we have? There's more pages. Oh, these are the previous filings. That's nice because now they're all in one court filing, right? With all the previous history of the alibi. Okay. Smexcellent. I don't know that you guys can pin messages. I think that only I can do that. Okay. Next up. Speaking of autism, defendant's response to the state's motion in limine of neuropsychological and psychiatric evidence. This is where there's some surprises here, as I just was referencing. All righty. So he's filed several related motions, it says I'm reading the footnote, that will be argued concurrently with this motion. Okay, the motion to strike death penalty, autism. Okay, right. Got it. All right. The state objects to the proposed testimony of Rachel Orr, arguing that the proposed testimony is outside of the mental condition evidence allowable under Idaho Code. This response is made pursuant to due process. Idaho Rules of Evidence 106 for a complete defense and a fair trial guaranteed by all of the amendments to the constitutions. The minute that the jury, and here we go. This is where we're starting to get a little bit of an indication that they want to bring it in earlier. The minute that jury selection begins, jurors will begin to study and analyze Mr. Kohberger's physical presence. They will watch his every move and pass judgment on him every minute of the trial simply based on how he looks and reacts to the presentation of certain evidence and comments about him. That's very true. Mr. Kohberger must be able to present testimony to the jury that he has certain physical disorders. It will assist the trier of fact to know his physical presentation, including nonverbal reactions in the courtroom, is explained by his physical condition. To exclude this evidence will result in an unfair bias that could cause a wrongful conviction. This objection is supported by the declaration of Dr. Jeffrey Lewine, and they've got an exhibit there attached. Mr. Kohberger in no way suggests that expert testimony related to his autism spectrum disorder, OCD. Okay, so now I guess there's an OCD diagnosis as well, and developmental coordination disorder are for the purpose of showing that he does not know right from wrong. He has at all times and continues to assert his actual innocence in this case. Okay. The state correctly noted in its motion, Mr. Kohberger's disclosure states that Dr. Orr's testimony and Dr. Ryan's testimony is not intended to be a mental element defense pursuant to the Idaho Code, but rather this testimony about state of mind, as well as factual defense testimony to anticipated testimony elicited by the state. So, okay, that makes sense. What do I mean? Oh, you're talking to P. Fox. Okay, got it. All right, celebrate, yes. Idaho Code is not limited to admission of either direct or rebuttal expert testimony to elements of the crime. Wait, we need to see what that statute is, because sometimes they will include the statute unless it was stated. Let me see here. Nope. They did not actually even paraphrase it. So let's pull that up. Okay, give me just a sec. It's 18-207. Okay, so here's section 2. If by the provisions of section whatever the fuck, Idaho Code, the court finds that one convicted of crime suffers from any mental condition requiring treatment, such person shall be committed to the Board of Correction or such city or county official as provided by law for placement in an appropriate facility for treatment, having regard for such conditions. In the event that a course of treatment thus commenced shall be concluded prior to the expiration of the sentence imposed. So that's interesting. Hold on, let me go back to the beginning of this. So it initially says, okay, 18-207, mental condition, not a defense. provision for treatment during incarceration. Oh, and then notice an appointment of expert examiners. Okay. Mental condition shall not be a defense to any charge of criminal conduct. So this is kind of saying it's not a defense, right? But they do say that they will provide treatment for a mental, but that's wild, right? It's like, yeah, we're acknowledging that you have some sort of mental condition that is going to require, an appropriate facility for treatment, right? Can you guys see where it's highlighted? Yet it's not going to be used for defense. That's crazy. So let's see where the, oh, they didn't cite a subsection. That's interesting. They did not cite a subsection. Okay, they just said 18-207, so like this entire thing. So, okay, so the part about the treatment, we read that. In the event the sentence has been imposed, the defendant shall receive treatment, da-da-da. So it sounds like they're supposed to be in the proper facility before even trial. And then after, if they're going to be given incarceration after sentencing, then that they should also be provided that. And then it says, like, if the treatment, okay, in the event that a course of treatment has concluded prior to the expiration of the sentence, then the offender shall remain liable for the remainder of such sentence, but shall have credit for a time incarcerated for treatment. In other words, sounds like they'd be remanded to the regular facility if their treatment is concluded, but their sentence is not. Nothing herein is intended to prevent the admission of expert evidence on the issue of any state. Here, this is the one. This is the one. Let me read this again. Nothing herein is intended to prevent the admission of expert evidence on the issue of any state of mind, which is an element of the offense subject to the rules of evidence. That is key. So again, so they're saying, while you can't use it as a defense, it's not to say that you can't bring in expert evidence to show the state of mind, if it's, as long as it's an element of the offense. Okay. No court shall, over the objection of any party, receive the evidence of any expert witness on any issue of mental condition or permit such evidence to be placed before a jury unless such evidence is fully subject to the adversarial process in at least the following particulars. Which means, so, okay, what does this matter? This pertains to their experts, right? So again, experts are allowed, but that expert evidence is not allowed if you don't do these things. So notice must be given at least 90 days in advance of trial. Okay, check, they've done that. A party who expects to call an expert witness to testify on an issue of mental condition must, on a schedule to be set by the court, furnish to the opposing party a written synopsis of the findings of such expert or copy of written report. They are doing that, so check. Raising an issue of mental condition in a criminal proceeding shall constitute a waiver of any privilege that might otherwise be interposed to bar production of evidence on the subject, and upon request, the court shall order that the state's experts shall have access to the defendant in such cases for the purposes of having. Okay, so what this is saying is that the state has the right to have their own experts also examine the defendant if they do want to bring in expert witness testimony about their mental state. The court is authorized to appoint at least one expert at public expense upon a showing by an indigent defendant that there is a need to inquire into the questions of the defendant's mental condition. If an examination cannot be conducted by reason of the unwillingness of the defendant to cooperate, the examiner shall so advise the court in writing. In such cases, the court may deny the party refusing to cooperate the right to present. So if the defendant is like, nah, you can't examine me, then it's like, well, then you can't present this information, this testimony, right? That's goes without saying. I feel like, well, I mean, nothing goes without saying in the law, but that makes sense. That's fair. So, okay. So they are saying we're allowed to bring this in. Yeah. It's not used as a defense of the charge, right? Mental condition shall not be defense to any charge. It's not a defense, but they can bring it in as long as they've met these following criteria, which they are doing and have done. So there we go. Now we know. Now we know. All right. So Idaho Code. So it's not limited to the admission of either direct or rebuttal to expert testimony to the elements of the crime. Because of the statute's broad application, the Idaho Supreme Court has determined that Idaho Code 18-207 applies to legal proceedings before trial, including pretrial motions. Okay. The threshold test for the admission of expert testimony is whether the scientific or other specialized knowledge of the expert will assist the trier of fact to understand the evidence or determine a fact and issue. The function of the expert is to provide testimony that is beyond the common sense experience and education of the average juror. Where the normal experience and qualifications of lay jurors permit them to draw proper conclusions from given facts and circumstances, then expert conclusions or opinions are admissible. In this case, it is not the normal experience and qualifications of lay jurors to understand ASD, OCD, or developmental coordination disorder. I'm sure we're going to learn more about this because I don't know what this is. I think we're all pretty well familiar with autism spectrum disorder and OCD. All right, first we're going to get started here with some autism. Alrighty, the anticipated testimony of Dr. Orr and Dr. Ryan is relevant to explain that Mr. Kohberger's ASD diagnosis is a physical condition and how it presents in his demeanor. Mr. Kohberger has met the criteria for this diagnosis since childhood, and that is not a convenient diagnosis given his current legal situation and jeopardy. So that's referencing an exhibit here. So that means that this is probably quoted from one of their experts. The anticipated testimony of Dr. Orr and Dr. Ryan is relevant to explaining how the behaviors and mannerisms presented by Mr. Kohberger are consistent with an individual having ASD. In addition, their opinions explains the neuroimaging of his brain that supports the ASD diagnosis. ASD is neurological disorder that is physical. While most people ordinarily think of it as a mental health condition, footnote 2, several Idaho statutes list conditions that fall within the meaning of serious mental health issues. And there's another footnote that's coming right up. We'll just go ahead and read it. In Idaho, developmental disability has been defined as a chronic disability of an individual which appears before the age of 22, which is attributable to an impairment such as autism. Okay. So it is and that's where the footnote 3 is, we just read, a neurological and developmental disorder that affects how people interact with others, communicate, learn, and behave. According to the U.S. government stuff, ASD is a neurological and developmental disorder that affects how people interact with others, communicate, learn, and behave. Some of this might overlap with what we've already read from the other filings. So if it does, I will not be redundant by reading it again. But they're saying here you need an actual examination because you can't see inside the brain. True. That's a fact. Can't see inside people's brains. Well, not without special imaging anyway. Research on large groups of persons with ASD has indicated the presence of structural differences in the brains of these groups versus those of individuals with typical neurobiological development, which also supports the conclusion of the people that it is a neurological disorder. Imaging of Mr. Kohberger's brain is reported in the attached declaration shows findings of structural differences in the physical makeup of his brain in areas commonly associated with control and expression of behaviors commonly seen in ASD and listed below as taken from the government's website. Symptoms of an actual behaviors commonly associated with OCD are common in people with ASD. That makes sense to me. As a physical condition, ASD may not be as noticeable as some physical conditions like a missing arm. If Mr. Kohberger had the physical disability of a missing arm, the jury would not require explanation about how such a physical condition might impact the case. That's a good point. They're saying this is a physical condition, but you can't just see it with the naked eye. ASD is visible in some ways that will be apparent to a jury, but requires explanation. Yep. Without explanation, the way that the public perceives the behaviors and mannerisms of someone with ASD is not always favorable and may be prejudicial. While Mr. Kohberger's presentation is highly consistent with ASD, without explanation, others may misinterpret and misidentify Mr. Kohberger's behaviors and cast them in a more sinister light, as people are wont to do. For example, he does not show emotion on his face. He has a flat affect. He sits very still and holds his hands in the same position. And literally, we've seen this in every single fucking hearing, right? He has a piercing stare. He does not show expected reactions. Facial expressions do not reflect what he's feeling. He's stiff in body posture. He has prosody in speech. I don't know what that means. Let's look that up. New word. Oh, I guess it's prosody, not prosody. Nope, I said it correctly. Okay, prosody, weird sounding word. The patterns of rhythm and sound used in poetry. So it comes from the word prose, right? So that makes sense. So it comes from the word prose. So he he speaks that way. That's interesting. Uses repetitive phrases and large words and has developmental dexterity problems. Interesting. Many of his behavioral characteristics are known to be commonly associated with the presence of ASD and are clearly relevant to the interpretation of his behavior in the courtroom by the jury, and may also be relevant in evidence regarding the rebuttal of evidence as to the commission of the crime itself. Oh, like having the dexterity to hold a knife, for example. Interesting. So the developmental dexterity problems, as you guys have maybe heard me say before, I've had violin students, and currently have, that are in varying, places on the spectrum, right? But one student that I had that had very, very, very severe ASD that was due to a number of severe seizures, had at birth, basically. This young student had severe dexterity problems, to where she couldn't hold a pencil or do a button or whatever. Her hands So that was one of the reasons why she started taking violin lessons. It was to develop that dexterity, and it really, really helped a whole lot. So I've seen that firsthand as well. Shout out to Too Fast for Fleas. Excellent. Power Bowl for breakfast. Power up. Good. Love it. Okay. So many, oh no, we already read that part. Right. Yeah. So that's an important thing, right? Like, again, the thing with the hands is very, there's a specific type of way that they, well, at least this one student that I had, but I think it's pretty common. Like, I think this is what they're going to be getting to, right? The way that the usage of the hands, it's kind of like, this student's hands would be like frozen almost, if you will, in like a claw type position. And she would have a hard time using the fingers and like closing the fingers to the thumb, basically, if you will. Again, think about anything that requires grasping, like a pencil or button. I gave those examples, but that would pertain to holding a freaking knife, wouldn't it? So that is where they're saying, that brings, remember, they have to, according to the statute, right, they have to show the relevance to the actual crime. So further explanation about ASD by the U.S. government is helpful. It provides the following on its website. The list below gives some examples of some different behaviors. Okay, so making little or inconsistent eye contact. Yeah, where is Tonka? I don't know. And where's Twiz? Twiz is probably asleep. Appearing not to look at or listen to people who are talking. Infrequently sharing interest, emotion, or enjoyment of objects or activities. Not responding or being slow to respond to one's name or verbal bids for attention. Having difficulties with the back and forth of conversation. Often talking at length about a subject of interest without considering social cues. Displaying facial expressions, movements, gestures that do not match what is being said. Having an unusual tone of voice that may sound flat. Having trouble understanding another person's point of view. Difficulties adjusting behavior to different social situations. Difficulties sharing an imaginative play or making friends. And then restrictive or repetitive behaviors may include repeating certain behaviors. And this is where you can see the overlap with OCD, as mentioned before. Having a lasting, intense interest in specific topics. Showing overly focused interests. Becoming upset by slight changes in routine. That was very, very, very true with that same student I referenced earlier. Any change in routine was completely destructive to this student's progress. And it was like just very detrimental. I'm sure that it varies depending on where you are on the spectrum, but yeah, a change in routine. But you can also see, again, there could be an overlap there with OCD, which again, they're saying they're going with both here as well for that. So autistic people often have sensory differences, such as being more or less sensitive than other people's sensory input. Yep. I've seen that in students as well, such as light, sound, clothing, or temperature. They may also experience sleep problems and irritability. Interesting that they included that because, that could go hand in hand with driving around at night, couldn't it? If you can't sleep. Based on a reasoned analysis of discovery provided by the state to date, Mr. Kohberger's behaviors that are attributable to his ASD and on this list of common behaviors of persons with ASD, along with other behaviors, must be presented to the jury to confront and rebut certain evidence to be proffered by the state. And now we're getting to the OCD part. Excelente. We got a breakfast recipe here from Too Fast. Eggs, fried potatoes, sausage, diced tomatoes, toast with jelly. What kind of jelly? Wow, that's a large breakfast. Oh, yeah. P. Fox's chopsticks would be a hell of a challenge, I bet. You know what's really funny? I struggle so much with, I've never gotten the hang of chopsticks. It's really funny. I have a lot of dexterity from music, right? Obviously. But it's a very different type of dexterity that doesn't transfer the chopsticks. It's really funny. I've always struggled with those, but not like I've ever really needed to use them all that much, Not a huge sushi eater, being vegan and whatnot, even though, there's vegan sushi. But yeah, it's like not going to be like, oh, I have a hankering for vegan sushi. Anyway. So Too Fast, you also have trouble with chopsticks? Right. Yeah. It's like a Burger King breakfast bowl plus tomatoes. Grape jelly. Pretty classic. Going with the grape. Cheater. Who's cheating? Okay. OCD can be an independent diagnosis, but is also a set of symptomatic behaviors that are often comorbid in ASD, as with Mr. Kohberger's ASD. Notable, for example, on the above list of behavioral issues commonly associated with ASD, Mr. Kohberger has sleep difficulties. Literally, I said that. and subsequently developed a habit. Oh my God, literally. That is so funny. Night driving or running to decompress. Such behaviors being present most of his life. He also engages in frequent compulsive hand washing, wears gloves to avoid germs. Interesting that they mention that, right? Interesting, but it makes sense. I can understand this. I understand why this is so important to get this in front of the jury as soon as possible, right? Has a fear of getting things into his eyes, changes his shower curtain frequently to avoid exposure to mold. Now, some of these things are going to be, okay, something like this, right? Changing his shower curtain frequently to avoid exposure to mold. I don't see how that's going to be able to come in at trial unless that comes from his testimony, because there's no way to verify that, right? Like it could be an expert's like, well, he told me, but I don't know that that would be able to come in, because typically when you've got experts that are talking about mental health, they don't usually rely on what the defendant told them. Now they will rely on how they may be performed on a certain test where it's like, okay, well, the defendant answered it this way, but that's, and then it yielded whatever the results were. But that's different than being like, I interviewed them and they told me, you know? Interesting. I had another thought and I lost it. Crap, what was my other thought? Okay, so changes his shower curtain frequently to avoid exposure to mold and avoids anything he views as contaminating. If the state elicits testimony at trial related to those types of facts that are used to build circumstantially the elements of the crime, or show Mr. Kohberger's actions as reflecting a state of mind or other elements of the crime, he will refute that evidence through expert testimony as behaviors related to his OCD and ASD. By way of specific example, the state has continued to claim that Mr. Kohberger was wearing gloves. Yup. That's why I said it was interesting. Wearing gloves on the night of his arrest and placing trash in baggies. The state asserts that this demonstrates that he had a consciousness of guilt and was trying to hide his DNA or engage in the cleaning of his car. This is highly prejudicial and misleading. Mr. Kohberger frequently wears gloves to avoid germs on surfaces. He was not cleaning his car on the night of the arrest. He was awake at night, as is typical for him, and was cleaning his bathroom. Oh, I know what I was going to say a second ago. That it doesn't surprise me that given like ASD and OCD as diagnoses, that and therefore doing things such as wearing gloves and all the stuff that they mentioned, it doesn't surprise me that they would want to get this in as early as possible in front of the jury so that they could understand the evidence. And then also maybe some of his mannerisms. The thing that surprises me, though, is like, again, it was very clear from the previous filing from the defense that they intended to bring this in only in mitigation. And now it's in the interim period of time, which wasn't that long, they seem to have changed their strategy on that, which is interesting. I don't know why they didn't just from the outset say they intended to use it initially, like for the guilt phase as well. And even probably in jury selection for that matter. So yeah, mold spores. Mold is awful. I've had terrible mold poisoning before, so I can relate to that. The state asserts that, okay, no, we read that. Okay. While testimony related to these topics may not be relevant until the state opens the door, okay, by eliciting testimony on these issues, once it does, okay, I see. So now that maybe just answers my question, right? In other words, they're not planning on it, essentially. Although it seems like they want to get it in at the beginning, like, again, the jury selection. Anyway, well, I'll keep reading. What they're saying here sounds like they're not planning on bringing it in during the guilt phase unless the door is opened. However, we can bet that door is going to be opened because essentially, oh my God, why are we doing these things? No, Adobe, don't be crazy. Okay. Because we know that they're going to want to bring that up, right? The bit about the gloves and the trash, So again, it's almost like that game of chicken. It's like, okay, state, what do you cannot bring it in, and then we won't bring in the autism, right? This reminds me a lot of the IgG. And what was the other strategy we were talking about earlier tonight? That was something else kind of similar. The text messages, I guess it was. No. Yeah, no, it was the text messages because of the idea that, like, okay, state, if you want to bring in some of it, we're going to have to bring in all of it because of the rule of completeness, right? Very interesting. So they're saying if the state wants to bring it in, they open the door, and then we're going to bring in the autism. All right. So such relevant evidence can assist the trier of fact In evaluating circumstantial evidence the state may put forward, since all testimony would be subject to vigorous cross-examination, it would clarify and not confuse the jurors. Now, the only thing that I'm going to push back on is this, because, they've got kind of two main points to this, right? One reason that they're discussing wanting to bring the autism in, right, is in order so that the jury doesn't judge his mannerisms as a certain way. Now, another interesting thing to note is they mentioned many times the flat affect in his speech patterns. Again, is that alluding to him taking the stand, right? Maybe, we don't know. But they do mention that a lot. That wouldn't be relevant if he just sits there and quietly, right? But like things like the way he's sitting and his staring, yeah, that's going to be relevant no matter what, because he's going to be sitting there at a minimum. But then there's the second thing, which is explaining some of the items of evidence, potentially being able to hold a knife, using the gloves and whatnot, right? Like they were just saying. Being up at night and going, late night driving and whatnot. So while the second category, right, related to the evidence that we just mentioned, I can see that makes sense with the whole thing with like opening the door. But as far as the mannerisms are concerned, it seems like they would still want to get that in front of the jury right away, regardless, right? Because like, again, like from jury selection, so that that's not dependent or contingent upon anything else. Like he's going to be sitting there. They're going to be judging him, if that makes sense. So I don't know if they're going to try to split it into two categories or what, but we'll keep reading. Unless it's just because they're assuming that the state's going to, but see, if they're waiting for the state to open the door, then they can't get it in until that happens. Right. So like, I don't know. Anyway. Okay. Developmental coordination disorder. All righty. Okay, Mr. Kohberger suffers from deficits in fine motor dexterity. Okay. And visual motor function. Interesting. I wonder if this is like the visual snow stuff. I don't even know if any of that was true. It's just, it's just interesting that they're saying that. Clearly, these are physical issues. He has experienced these physical impairments all of his life. The state has disclosed evidence that law enforcement will testify. They did test runs at 1122 King Road, and that it is possible to commit 4 homicides in a time frame of only minutes, including walking from a car. This is also where the 3D model of the house comes in, I guarantee you guys. Because I guarantee you part of what they're going to try to use that for is to substantiate this whole thing about the timing. How much you want to bet? Including walking to and from a car and removing clothing that would be covered in blood. Additionally, state has disclosed a forensic pathologist who will testify regarding the manner and death, injuries, and specific wounds on the deceased. That's sorry, let me just back up. The test runs. Hang on. Are you saying that they had law enforcement try to kill 4 people in that amount of time? Because I have questions if that's the case. Mr. Kohberger has disclosed a forensic pathologist who has some differing opinions. I love it. Thank God. That is amazing. Dude, we were watching with Murdoch, the most recent one. We were watching Dr. Ellen Reamer. I hope I don't know that they're bringing in Dr. Reamer, but dude, she's amazing. Like I was saying last, we were watching Murdoch. I was like, dude, everybody, they could call her. They have that ability and she's amazing. So anyway, but then they have a forensic pathologist who has some differing opinions, including injury and specific wounds on the deceased. Wow. It will be relevant for the jury to know that Mr. Kohberger has a developmental coordination disorder that impacts his fine motor dexterity and visual motor function. Such speech and coordination are not possible for him. So they're saying there's no way he could have done it. Wait, why did you laugh so loud? Did I say something funny? We have a derp durable command now, guys. Speaking of vacuums, derp durable for life. Also, shout out to Meg. So I'm still trying to figure out why Heather's laughing so loud she woke the dog, but glad she's laughing. Who's Doug Wilson? I can't fucking remember who Doug Wilson is, guys. Oh, okay. Yeah, no, all right. She's saying she was laughing because of the thing about lawn. I mean, literally, that's what they said, though, right? They did a test run. Like, what the fuck? And actually, it's test runs plural. So wait. 4 people times how many test runs, right? Test runs plural, at least 2. So that's at least 8 people they must have killed. There's the durable command. Like, can someone remind me who Doug Wilson is so I cannot be left out? That's so funny. I guess Kane is saying he put me on 0.75 speed so he could hear me talking. That's fucking funny. Yeah, I'm a fast talker. Fast talker. Conclusion. Doug. Oh my God. Mr. Kohberger has a right to confront. Okay, right. Court should deny it. Deny it. Let them testify. The physical disorder. And so this is, again, right, going back to what I was just saying. Jury selection, right? The physical disorder of ASD should be allowed at the outset of trial. Okay, now I'm going to take issue with this, and here's why. I don't take issue that it should be allowed at the outset. I agree with that. I'm taking issue with this from the argument here. Here's what I take issue with. Because of all this stuff, I was just getting confused. Not even, like, remember just a minute ago when I was like, well, hang on, right? The bit about opening the door, like, here. Like, while I freaking love anytime opening the door is discussed. I love it coming up in trials. One of my favorite fucking things. Like, love it. But right here, while testimony related to these topics may not be relevant until the state opens the door by eliciting testimony on these issues, once it does, I mean, so I worry that what's going to happen is somebody's going to be like, hey, like either the state or the judge, right, is going to be like, well, you said you were fine waiting for it until the door was opened, right? I guess they're going to break it down piece by piece in terms of what will come in when, like, potentially that, and this is kind of what I was saying, right? The two categories, like potentially that the unable to grasp things with his hands just as an example, right? Like the dexterity, like potentially maybe that doesn't come in until they mention wielding a knife rather, or whatever the fuck, or that the wearing of the gloves, again, as another example, they may not bring in the hand washing and the gloves until that. And then maybe what they're going to want to do is say that from the very outset of trial, right, as it says here, they can get into the things like the mannerisms, which is what I said. The thing I'm still going to take issue with it. And here's why, because they're not making it clear. They should make it clear what they're asking for, right? If you want the court to grant your motion, you should make it clear. If you're going to put it like, and like the only reason I'm even complaining about it is because they are the ones that said, well, some of it may not be relevant until the door is opened. It's like, okay, well, now that you've said that, right, now you need to make it clear what you do want allowed at the outset of trial. Okay, I'll finish wrapping up this document. Issues related to his OCD symptoms that are an outgrowth of his neurological disorder and developmental coordination disorder may depend on the evidence that the state literally, hang on. I don't know, you guys, this might be a first. I don't know that I have actually goated yet. Goat warning ahead of time. I don't think I've ever goated in a defense filing for this case yet. It's a first. This is a first. Gave you all the goat warning. Goat warning. Goat warning. An excited goaterance, as it were. Because literally they just did it in one paragraph, the contradicting part, right? Let's take a look again as to why I goated. More specifically, the court should allow Dr. Orr and Dr. Ryan to testify this part. The physical disorder of ASD should be allowed at the outset of trial. Okay. Issues related to his OCD symptoms that are an outgrowth of ASD and the developmental coordination disorder may depend on the evidence the state elicits as the trial proceeds. They're going to have to spell it out. Because especially because of the overlap, right? Like what is specific to the ASD and not the OCD? What's an overlap? And that's where, I don't know, they should have made this more fucking clear what they're asking for, I think. My personal opinion. Meg is here. Coast is clear, Heather. She muted me. Coast is clear, Heather. Yeah, at least I was able to give you guys a warning this time. Sometimes it is more spontaneous, but this one got a little bit of a warning. Okay, let's zoom out a little bit more. So now, look, guys, it's a brain. So here's his declaration. Let's just see what this says. So there's his background. We're not going to worry about going through all that. Let's just see if he says anything specifically about his findings. It is, okay, I'm looking at number 9 here. It is my understanding that Mr. Kohberger has received several diagnoses. Oh, no. Oh, God. Look, guys, look. Oh, dear. What do we have going on here? Do I have to goat again? I'm going to try not to goat. I've got my finger on the goat button. I'm going to try not to goat. Y'all, help. You know, here's the thing. You're an expert, right? And like I said, we're not going to even read all this stuff because I'm sure he's like really fucking overqualified. Like, I've done all of the things, brain work, go brain, all this stuff. I'm super smart. And then you follow that up with this type of thing. And it's like, well, several diagnoses. See, my brain, when I was reading this, I was like, wait, did he say diagnosis and mean to say diagnoses? Because when you see several, you know it should be plural. But then I was like, oh, wait, it's worse. It says diagnoses. All right, I'm going to keep reading, not to goat. From appropriate and qualified doctors. For the purposes of this declaration, for this motion, I'm addressing only three. ASD level 1, without accompanying intellectual or language impairment. Developmental coordination disorder. And obsessive compulsive disorder with absent insight. What does that mean? Let's look it up. OCD with, oh my God, with absent insight. Oh, I know. The non-proofreading is too much for me. I lost it. I lost my shit earlier too. It's just. Okay. So when it's absent insight, it means that the individual is convinced their obsessions and compulsions are rational and necessary, rather than recognizing them as irrational or excessive. So for example, if somebody washes their hands 100 times a minute, not that that's even probably possible, but let's just say, right? Might be some people with OCD that don't have the absent insight and they're like, yeah, this is crazy. I wish I could stop, but I can't. Like, I understand this isn't rational, but if you're absent insight, it means that they think it's rational and necessary. So that's what they're saying he has. It is also my understanding that the state of Idaho has requested that the court issue an order in limine prohibiting defense from offering testimony regarding neuropsychological evaluation and psychiatric evaluation of the defendant in the guilt-innocent phase of the trial. Okay, here we go. More information on this, guys. The stated argument. I really thought the defense was saying they were going to do this anyway. Again, it seems like they're changing their tune on this because, I mean, hang on. I can't leave this be. Hold on. Let's just go back to it. Oh my God. Where is it? All right. Wait, that's the state's motion. Wait, hold on. We need the defense's motion. Oh, I guess. Oh, interesting. Okay. So what the heck? So this was an original. There's a lot of back and forth, right? Because it's like you have the initial filing, then you have like the objection, then you have the reply to the objection, and there's a lot of documents. I guess I was thinking that this was initially a defense filing, but it looks like it was initially a state filing. Yeah, this was initially a state filing. Okay. So we're just taking a look. But this, hold on, because the defense responded already because we fucking read it. So what we must have read must have been regarding the expert witnesses. Okay. That's funny because they're citing that same exact statute that we looked up just a few minutes ago or like earlier that literally says you can bring it in. Literally says you can bring it in. Look at this. I mean, the thing is now we know that this is bullshit because we read the entire statute. And it says it provides that mental condition shall not be a defense. Yeah, but after that, it goes and says, yeah, you can bring it in to show mental state and gives all the reasons that you can, and then the exceptions as to when you can't. And the states just conveniently leaving all that out. So I think where the thing came in, where it was, okay, where it was like going to be only in the sentencing phase, right, is because that would be one way around this thing, because it's like if it's not to prove any element of the crime, like that would only be applicable for the guilt phase, right? Because you're not doing, when you're in the sentencing phase, that's no longer relevant. But where is, hang on. I mean, where was the defense filing? Jesus Christ, let me just look through these. The defense filing, the one that made it very clear they were just going to use it during mitigation. Oh my God, there's just so many filings. And they redid the whole thing, and now it's all annoying because I was so used to it the other way. Oh my God, you guys, y'all are talking about morticians. Hold on. Hang on.
My friend Elizabeth is a mortician. She's the prettiest mortician I've ever met.
You guys, Andy's friend, the fucking mortician. What is happening? Here you go,
Yesterday,
Heather.
I was taking a walk around 5. I met a new friend. We went to Tallahassee food trucks.
Wow.
Last night, hung out with her for hours.
Yeah.
Wendy made another new friend? Are you fucking kidding me? Why?
She also Googled. There was a shooting, do you know?
I know.
Both she and John.
Stop.
Why would they
I'm
Google?
going to die.
Why would that just
Dude,
come
I'm
up?
going. Sorry. Heather says, I met a new friend on a walk. Bitch, how old are you? In the interim, I found what I was looking for. And I was looking. What song is that? Hold on. Oh, it's that one. Do 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 do. What song is that? Do do. That I found. What is it? Something. It's about like I found what I was looking for. Anyways, whatever. Okay. I found what I was looking for. Oh, Fievel. What song is that? God damn it. Kane, do you know? Here's some Fievel for you guys. Did y'all hear the news? I said this on the earlier stream, but I'm going to repeat it because it's worth repeating. That with all the fuckery with the attorney conflict and all that in the Adelson case, right? Speaking of Fievel. So, you know, and Donna has all the new attorneys. So initially her investigator was allowed to stay on, right? But there was that recent hearing where her defense counsel was like, you know, we were learning that this conflict might run deeper than anybody has realized yet. Anyway, just posted on the docket, but the filing's not available yet, but it just posted on the docket like 12 hours ago. Order disqualifying investigator. So you guys know what that means. Fucking hell. Problems, and I don't think she's going to be going to trial in June. That's my my thought. Moonvale, welcome. Haven't seen you in a hot minute. Happy to see you again. And shout out to Autism. When is the strip trivia? I don't even know. I will say this much though, just to that end with the trivia. So you guys, so for members that are going to be involved there for the trivia, right? So we've had our first members only live. We did law trivia. So we're doing the next round of trivia is going to be where everybody gets a handicap, as it were, where everybody gets to pick their number one category that they think they will do best at in trivia. So for me, if I were participating and I were not the one doing the live stream, I would do classical music, right? So for the thing that you think you're the best at for trivia, and you get to pick one category. And for everybody that goes and submits their categories, I'm going to pick an even number of questions for each category. And there might be some additional categories, right? But in other words, everybody's going to get an equal amount of like a handicap, as it were, like in a good way, right? So what I was saying is if you guys want to do that, submit it in the Discord, go to the thread that says members only requests, and you can submit your one category choice in there. And so far, last I checked, only one person has done that, and that's Flash. Shout out to Flash Fan. He submitted his one category, and it was a wild card. We were thinking it was going to be either food or vintage trials, and it was mythology, surprising us all with that one. So shout out to Flash. Oh, maybe? I have no idea. You know what's so funny? I didn't know that I would recognize the name even if that was the correct one. Oh my God. Kane is wearing extra socks. Oh, that is hilarious. The strip trivia extra socks. Yeah, I don't even know. I guess we can do it without cameras, right? We can just do it, Scouts honor situation that we're doing strip trivia. We could do that. I'm totally fine with that. We can just narrate how much clothing we have left. I'm sure Flash is asleep, but we love Flash. You know so many things, Meg. Come on, girl. I guarantee you can think of a category you would accept. I mean, it can be if y'all, it can be one of the, what are the traditional categories in regular trivia, right? Like sports, movies. I don't know. I don't even know that I've ever been to one. I'm just guessing. Shit that most people, entertainment, I don't know. But it can be one of those normal ones, right? Or it can be something really specific to you that and there can be strategy, right? You might want to pick a category that you think no one else is going to know anything about. And I'm wondering if that's why Flash went with mythology, because I wonder if he thought to himself, because he's smart, I wonder if he thought food, vintage trials, that other people will be able to get points. But mythology, I mean, I don't even all right. So I wonder if that was a strategy. So if you pick something more obscure, so think about, we all know each other pretty well. Think about things that the other people won't know anything about. I shouldn't be giving y'all hints. You guys can figure it out. I'm just saying there could be some strategy involved for those of you guys who are extra competitive. So nursing. Okay. You might need to be more specific because I know nothing about nursing, but if you can be more specific, because I'm the one that's going to be coming up with these questions, right? What is this CAP thing? Is that an abbreviation or a acronym? Oh, I see. I see here. What is all caps? Heather's favorite. That's really fucking funny. Heather's favorite pastime. That's really fucking funny. Yeah. The first time Heather ever came into one of the, whatever live stream it was in the chat, and I didn't know who she, literally the entire time she was in chat, everything was all caps. This will give you guys some context. We are watching for the millionth time the May 30th hearing, the infamous one. Meg wants, you know what? If you want to partner with me and we can do, are you saying do the questions for you or for help pick questions? If you want to help pick questions for the crew, we can totally get together on that if you want, and you can be, you can do that for sure. But then you can't participate. We also talked about doing a Never Have I Ever, which would be really fucking fun. We could totally do that as well. I wonder if there's a way to combine Never Have I Ever with strip trivia. If one of you guys wants to figure that one out, that sounds like a good time to me. Most irrelevant information. Absolutely it can be one. Totally. Usually people that have that, a lot of what they say would be irrelevant or useless information. Usually those are the people who are really good at trivia. Yeah, if you want to help with the questions, totally. Maybe you can also help us come up with the Never Have I Ever strip trivia. Okay, so here we are. Where are we? I don't even know. We are here. We are here. So this is the filing. This is why I couldn't find it initially, because the title doesn't give it away in terms of looking through all those documents. Conditions as aggravator. So this is what I was looking for. This is the initial defense filing where they mentioned the autism as far as this is what I was looking for, right? Where it's like coming in as an aggravator, like even in the title, aggravator, that's talking about the mitigation phase, right? Right? Okay, let's all make sure we're clear. So they're moving the court from using it, the autism. They're going through the characteristics where we don't need to read all that because we are literally reading more about that in our current document. Is it appropriate for the prosecution to wrap mitigating evidence into an aggravator? So they're saying it's mitigating evidence. Again, we all know what that means. Mitigation / sentencing phase. And they're saying they don't want them to use it as an aggravator. Again, pointing to the sentencing phase. Literally. This entire thing is about mitigating or aggravating. All that is the sentencing phase. Yep. And then here, literally, the last thing. Mr. Kohberger respectfully requests the court prevent the state from using his diagnosis of autism or any characteristic thereof as an aggravator if a sentencing proceeding is held. So nowhere have they said they wanted to use it anywhere else. However, the state's filing that the defense is referencing in the current document we were reading does say they want to prohibit the defendant from offering testimony. And this would be in reference to the guilt phase, because they talk here about the criminal conduct and element of the offense. Okay. So let me just summarize this. So the defense's initial filing as it regards to the autism was to preclude the state from being able to try to use it as a aggravating factor during the sentencing phase. And everything was about the sentencing phase. The state's initial filing is saying that the defense shouldn't be able to bring autism into the guilt phase, basically, in summary fashion. Okay? This shit's crazy, man. All right. So now that hopefully is more clear. So this is the first time we are seeing a document from the defense saying they want to bring it in during the trial. Because they're only saying this in response to the state's initial filing that we just referenced, where they said we don't want you to bring it in during during the guilt phase, right? Guilt innocence phase of the trial, right? The state said we don't want them to be able to do that. So this is a big deal. So okay, all right. And so the other thing too is, right, like the problem is this. So mainstream media incorrectly kept stating, once the defense filing came out, they kept the one we just went over about aggravator, mitigator. They kept stating Bryan Kohberger wants to use autism during the trial as an excuse to, and they were referencing, they didn't read it, right? But they're talking about the guilt phase. And I kept correcting people like, no. They're bringing it in. They're talking about in the mitigation or the sentencing phase. That's what they're talking about. And that was true up until now. Now it's no longer true. The media had no right to say that then, but they can now, basically, is what I will say, because that's clear. Now they will, and I'm not saying it's a good thing or bad thing they want to bring it in. I'm just saying factually, they didn't say they wanted to bring it in before, and now they are. Hopefully that makes a sense. Are some of you guys going to bed or going away? Don't go away. Okay, I get some. Oh, that's fun. Meg says, who's most likely to? Example, who's most likely? That is fun. That's a fun one. That kind of reminds me of the other thing we referenced the other night, the game they play in Inglourious Bastards, where it's like the person has a name. Like there wouldn't be any way to do this particular game virtually though, but like that person has to guess who they are. But yeah, but what Meg is suggesting, there could be a way to do that. That sounds fun. Would that be considered trivia, or would that be a different game? Meeting new strangers on walks. Oh my God, amazing. Sunny Days, I don't think I've seen you in the chat before. If you're new, welcome. Glad you're still here listening. Love it. Welcome, welcome, welcome. We love the Squirrel Crew. Anyone that is new and wants to share where you're joining us from, please feel free. Don't have to, but you can. I try to remember where literally everybody's from. Meg facts. Meg's most likely to be browsing online. Don't we know it? Don't we know it? Okay, so where were we here? Okay, the stated argument relates to the Idaho Code, which provides, and we literally have just read this code, so I'm not going to read it again. In considering this, it therefore becomes relevant to distinguish diagnoses and evolutions. Oh my God, evaluations related to mental. Is that V supposed to be for versus? Oh my God, the proofreading. I'm sorry, the lack thereof versus physical conditions. I have therefore been asked to discuss the relevant scientific evidence with respect to all of the things. As an expert neuroscientist, I recognize three general categories rather. Okay, that's fine. We don't need to read all of this. He's making a distinction between a neurobiological condition, which is different from things like, major depressive disorder, for example, as he gave an example of that. As outlined in the by Dr. Orr, Mr. Kohberger has multiple diagnostic conditions. He's going to discuss the subset. So let's see here. Okay. Autism spectrum disorder level 1 without accompanying intellectual or language impairment. So on the one hand, his overall level of intellectual function and his general language skills have been adequate to allow him to complete a master's degree. But neuropsychological evaluation reveals deficits in several subdomains, including motor skills, processing speed, and executive function. Perhaps executive function, does that mean like being as the COO of a company or CEO of a company? Making a joke there. Perhaps most importantly, he demonstrates substantive impairments in social cognition that date back to early childhood. As noted by Dr. Orr, he demonstrates anomalies in nonverbal. Now, I wonder this dating back to childhood thing. I'm going to be curious. See, they're going to have to show where did they get that from? Did they interview his family? Is it from interviewing him? I'm just curious because I know I realize that's a thing, but like, how do you? And I'm literally saying this because you know that this is what we're going to hear from the state or from the judge or from anybody, right? Like, how do you know? Who did you hear it from? Who did you, and then you're going to have to be like, okay, well, we need to find somebody who's not biased who can validate that. I mean, maybe go back to his teachers. I don't know. I don't really know what the answer is. I'm just saying I can just see objections left and right. You know what I mean? As noted by Dr. Orr, he demonstrates anomalies in nonverbal communication, poor social emotional reciprocity, and impaired relationships, all consistent with autistic patterns. Whereas most patterns with most patients with ASD demonstrate intellectual and language impairments, it is well established that there is a significant minority of patients like Bryan where the dominant dysfunction is selectively seen with respect to social cognition. In part, this likely reflects the neurobiological reality of relatively distinct brain networks for language v. social skills. Can't we just type things normally? Whereas there was a brief period of history where autism was thought to be a psychological response to environmental factors, for example, refrigerator parents. What the fuck does that mean? Parents that are kept in a refrigerator? Parents that keep you in a refrigerator? What is that? Looking it up. Oh, okay. Yeah, it's a dispelled autism. Right. It's not a real thing, but they used to think it was a thing. Basically, it's saying having an emotionally cold or detached parents could cause it. Yeah, that's ridiculous. I mean, not that can't cause problems, but yeah. So for more than half a century, basically, they were saying they thought it was a response to environmental factors, right? And now we know it's not. Now we know it's a neurodevelopmental and has a physical biological origin. I hope all these exhibits are attached. They probably are because there's a number of pages, but yeah. Okay. Developmental coordination disorder. Okay, that is a neurodevelopmental condition that can co-occur, but is also distinct from ASD, also known as dyspraxia. Somebody in the chat was talking about this, and I'd never heard of it. Who was that? Somebody was talking about this. I don't even know if it was in relation to this case. It might have been talking about something that somebody they know has or something, but I recognize that name and I hadn't heard it before until someone in the chat mentioned it. So development of, impairments in the development of motor coordination, including dexterity, limb speed, and motor skills, both gross and fine. Like the ASDs, dyspraxia has high heritability. In other words, hereditary, right? Interesting. It is noteworthy that Bryan continues to show evidence of significant motor and coordination issues as revealed through formal testing with Dr. Orr. And then we have the OCD with absent insight. I had never heard of Yik Yak either. Somebody said earlier it's like related to sororities or frats. I don't know. Like it's a thing for that. I don't even know. Let me see what you guys are saying. Oh, you're also in Australia. We have a lot of squirrel friends in Australia. That is right? Literally right now, even Moonvale and sunny days. That's really funny because we got a moon and a sun. Oh my God, you guys should be like best friends. I love it. We've got a number of squirrel, even beyond even right now. We've got other squirrel friends in Australia. Love it. Good day to you guys. That is awesome. Y'all are, oh, look at this. See, you guys are way ahead of me with this. Okay. I'm just catching up because it's harder to read the chat while I am also reading the documents, obviously. Okay. So OCD. So, right. Bryan reportedly from who? Again, these are questions that are going to be asked. Developed compulsive hand-washing behaviors as a young child, a fear of getting things in his eyes and avoidance of germs. Yeah, who's going to testify to that? Bryan or a family member or what? There is substantial evidence that OCD is primarily a neurobiological disorder, although it is not necessarily a neurodevelopmental disorder. Evidence in support for its biological basis include, okay, we don't need to read all this. It can be caused by viral infections. I didn't know that. Imaging studies also demonstrated clear neurobiology for OCD. And they saw it on his brain. Also, stress can impact it. Yep, that makes sense. In general, OCD is not considered to be a neurodevelopmental condition per se, but it is biological in nature, and in Bryan's case, manifested early in development. In summary, based on my training experience, okay, yeah, we know. We don't need to read all that. Okay, what's the next one? So then we have another doctor here, all of his things. Does he proofread, though? That's at this juncture all I want to know. Do you proofread? Please do. Yeah, no, I guarantee you're not the only one who. I think anybody who knows what Yik Yak is probably because they Googled it because of this case. I doubt anyone knew what it was before, more than likely. And I'm sure there's tons of people that maybe just aren't in the chat right now that also did not know what it was, and still are not clear on what it is. So he did a lot of shit, but can he proofread though? That's really the question at hand here. What's with the prices? You guys, like, why is there not dollar? What is with the? I don't know what that's about. Does that mean he got paid? I don't know what the I don't know what that is. Direct costs. I don't know. I saw it. Okay. Wow. Lots of things. This is more things than the other dude. Way more. Look at all of my expertise. Good thing he's not going to be there for Squirrel Crew Trivia night. Am I right? Oh my God. And it goes on. and on and on and on. My God. Is it going to get to any of his findings, though? Because we're on, like, oh, maybe that's the same dude? I don't even know. What? Hold on. Wait a second. Wait a second. Okay, hang on. Okay, it's the same dude. But what about the other? What about Dr. Orr? Isn't Dr. Orr supposed to be the most important one? That was like their primary one. Yeah, I mean, I expected some of those other pages to be Dr. Orr's, what is it? I guess it's an affidavit? Declaration. I expected there to be Dr. Orr's declaration. It's just him. Because I thought she was, or he or she, I don't know why I'm picturing a lady. I thought he or she was the primary, neuropsychologist, but it's just this one dude. Okay. All right. Well, we're done with that one. So next up. All right. You guys ready for this one? States. We're on to the states. Hi, Carla. Welcome. So we got our answer. Yeah, right. Yeah, we got our answer. He did not proofread. The part where it said diagnoses, or whatever it was, and then the V's, yeah, didn't proofread. He did not proofread. Carla doesn't know what I honestly, I really don't know. All I know is what somebody said earlier tonight in the earlier live stream that has something to do with sororities and frats. That's as much as I can say, literally, about it. I feel like the name is already getting annoying to me, though. Okay, here we go. Amazon clickety clicks. Moonvale putting the Google skills to work there. Thanks, Moonvale. It's a chat within a 5-mile radius. Okay, so is it not at all limited to frats and sororities? It's just 5-mile radius? Yeah, I was thinking that too, Meg. Durable. All right. 4 victims were found deceased with apparent stab wounds. Yes. A Kohberger knife sheath was found. We know. Okay. On April 26, 2023, the state applied for and was granted a search warrant for Bryan Kohberger's Amazon.com user activity. This search warrant was amended by Magistrate Judge Megan Marshall on May 8th to correct a Scrivener's error. Shaking my head. Okay, so it directed law enforcement to seize from Amazon 1, Bryan Kohberger's, quote, customer click activity pertaining to knives and accessories. 2, payment methods used. 3, details of items in carts to include all items added to cart, all items removed or deleted from cart, wish listed or shopping baskets. 4, all suggestions made to the account. 5, all records regarding reviews by other Amazon users viewed by Kohberger. Number 6, advertising data. Number 7, devices used to connect to account. 8, all account linked to account. I think that's supposed to say accounts plural. What I wonder, okay, remember guys from the defense filing, one of the things that really stuck out to me was like his account was a household account and all of his family used it. So I wonder, is the state just going to completely ignore that, or are they going to address that? Because literally that's a problem. Like, because anybody from the account can purchase anything and have it sent anywhere. And one thing we learned from the defense filing is that what the Amazon doesn't show, it does not show which device was used to purchase something. So for example, one person could buy something and select another family member's credit card or whatever, not saying to be shady or whatever, they just could do it accidentally or for whatever purpose. So like, in other words, the address where it's shipped and the card used won't necessarily indicate who bought the thing or wanted to buy the thing, made the action of buying it. Potentially being able to say what device was used could, but it doesn't know. So I just wanted to point that out for anyone who missed it, that was a thing. So like, for example, when it says this shit, this is why it bugs me. All records regarding reviews by other Amazon users viewed by Bryan Kohberger. It's a household account. Like, for fuck's sake, people. Not you guys, state. Okay. So it has nothing to do with sororities and frats, correct then? Okay. All right. It's anonymous. All right. Thanks, guys. Y'all are awesome. See, glad we looked into it. Thank you, Moondale. Because now we know. Knowing is half the battle. Okay, the search warrant was limited to those days. Search warrant was served on May 10th. Great. On December 18th, the state disclosed Shane Cox, litigation and regulatory manager, for law enforcement response for Amazon.com. Okay. The state made this decision. Okay, they disclosed him as an expert. They made this strategic decision solely to ensure the state was not precluded from calling him as a witness if the court subsequently made the determination that his testimony is based on specialized knowledge. Argument. The Rule 106 does not apply to business records containing user activity records. Remainder of or related writings of recorded statements. If a party introduces all or part of a writing, okay, that's like a rule of completeness, similar to rule of completeness. A statement is defined as an oral assertion, written assertion, or nonverbal conduct if the person intended it as an assertion. Wait a second. I object to mind reading problems here, guys. You guys, let me read that again. A statement is defined as an oral assertion, written assertion, or nonverbal conduct if the person intended it as an assertion. Pardon you, Santa? How the fuck are you supposed to know what someone intended? Stop it. Okay. All right. I can't. I'm not going to go. I'm going to keep reading. If I keep reading, I can't go. Examples of related writings or recorded statements include 1, transcript of defendant's taped interview. Okay. These are from case law. So never mind. I'm not going to read all these. These are examples from case law. Fine. Defendant cites the Idaho Supreme Court's ruling in Ogden regarding the reasoning for the adoption of Rule 106, which is the completeness doctrine. As this court is well aware. So remember, okay, let me just back up. What they're talking about here is one of the many things the defense mentioned in their filing, besides the whole thing about being a household account, was like that it wasn't complete, that it didn't include all of the activity on Amazon. And so then they were citing the completeness doctrine. Okay, so that was one issue that they were taking. I think the household thing is, in my view, like the biggest thing. Twiz is here. Yay! Twiz is here. Doo-doo-doo. As this court is well aware, this is sucking up if I've ever seen it. As this court is well aware, Stephen J. Hippler was the presiding judge. They're citing his own case law to himself. That's disgusting. Ogden was a felony drug case. The evidence it issued, okay, I'm not even fucking reading all that. All right. This is just sucking up, in my opinion. The Ogden court, right, well, that's Judge Hippler. User activity from business, this is just dumb. I hope they say something about the household account, or I'm going to lose it. I will, listen, guys, I will just give you guys here. If we go through this whole document and they never address the household account issue, I will go myself into oblivion. I am still going, correct. I wasn't going all the way through, though. I had the one live stream, and then I started working on my next video for some of you guys who do the orchids. I started working on my next orchid video for y'all about pot size, and I was editing that, and then I was like, I need to take a break, and then I was like, I'm going to come back for more. Okay, further in this case, the evidence at issue is complete. What? The defendant argues that the data the state has disclosed to the defendant is extremely narrow when compared to the more inclusive and broad warrants and subpoenas. Right. I see what they're saying. Right. Because like in some of the subpoenas, they just like give us everything. And then in this one, it's like, here's some of the things, as in the Amazon, right? But this argument is incorrect. To confirm, the state has disclosed to the defendant all data, including clickstream data that Amazon has produced in this case. The state narrowly tailored a search warrant for evidence regarding the crimes of homicide or burglary at 112 King Road. This included temporal limitations based off the officer's investigation. From March 20th, 2022 through March 30th, 2022, open parentheses, time it was known, Bryan Kohberger purchased a K-bar knife with sheath and sharpener from Amazon.com, close parentheses. So, well, this is the first time we've seen this in a filing. but they don't say how it was known. So fuck me, right? Like, dude, what the fuck? This is some weasel. This is okay. These pleadings are fascinating. Again, I'm seeing, like I've talked about a lot of earlier tonight and earlier on this very live stream, there's the strategy and the gamesmanship. Again, this is honestly the gamesmanship. I don't say that in a bad way, although sometimes that can be meant in a bad way. I mean, the lawyering strategy that I actually is what makes this shit so fascinating, and I love it, right? Like I'm trying to figure out if you can see what their strategy is going to be at trial, right? It's the 4D chess of it all, if you will. But the other thing is that both sides are definitely trying to send out certain like messages to the public and sneakadoodle things in. It's very fascinating. I almost could want to go back. No, this would be insane. I'll say it out loud. I almost want to go see now that I'm saying out loud. No, I'm going to have to do it. Damn it. Fuck. I'm going to have to do it. Go back through all these documents. By all these, I mean, just this recent batch, right? It's not that many yet that I've covered, but go back through them and like highlight all of the things I think are in those categories, AKA the category of strategy at trial and like the 4D chess situation. And then also things that are meant, it seemed to be with the intention of wanting the public to learn the information now, right? To get that information out. And in a way, you could say it's also a way of trying to get around the gag order, right? Both sides are fucking doing it. It's very interesting. And I will say that with each subsequent round of filings, it's way more than it was the previous round. Like they're like it's just really funny. It's like the competitive nature is coming out. I've read all these fucking filings, right? The tone that I'm getting is like the competitive nature is really coming out. And now they're really trying to like one up each other. That's what I'm seeing. Are you guys seeing that? Like, it's really interesting on a psychological level here for me. Welcome back, official. Happy to see you again. I'm going to take a look at the chat because again, it's hard to read the chat while I read the document. Carla's orchid's about to bloom. Awesome. Love it. That's awesome. Remember, once it starts blooming, you can turn it around to face you. Glad it's about to bloom. Excellent. Caulk size. Me? Caulk size? I don't even know what that was in reference to. I doubt it. I'm glad I make you laugh, Meg. Excellent. That's what I'm here for. Great question. So if I share, okay, good question here. If I share an Amazon account and someone orders a blow up doll, you won't know what device or account ordered it. You will know the account, but not which device you won't know what device. You know which account, you'll be able to probably get the address and like the credit card, right, payment, but you won't know which device. So you've plausible deniability there if you want to do that. I'm sure Amazon has spicy stuff. I guarantee you. Somebody check Amazon for blow up dolls post haste if you haven't. Maybe somebody already has since I'm catching up here in the chat. I would imagine that's what's happening. I would imagine that's what's happening based on what I know of what people say. I guarantee you that's what's happening. I bet that's what's happening. Brian lost a blow up doll. Did anybody check and see if you can get blow up dolls on Amazon? We could just do this the right way, couldn't we though? As we are wont to do here. It's going to make me type these characters in. Because I don't even know that I've ever used Amazon on the computer ever. Isn't that funny? I never thought of that until now. It's like making me verify I'm a human and whatnot, it looks like. I'm not a human, I'm a squirrel, but you know. So now this is going to be on my Amazon search history. All right. Don't care though. That's all right. All right, guys, y'all ready? Yep, we've got, so, okay, we want ones, okay. Were we looking for the dirty, naughty ones? Oh, God. What? Wait, what? Why? What is happening? Why is there a lamb? Okay. Oh, dear. Oh, my God. Honestly, we could have a field day reading these descriptions alone. What the fuck is happening? What? Why? Oh, my God. They've got a hula theme going on. Oh my God, that is really creepy. Look at, can you guys see this one with where the mount? That is really creepy. Oh my God, oh my God, oh my God, oh my God. The chest hair is really funny. Yeah, there's a bunch of those. It seems to be a popular choice. The chest, why? They're like, it looks like they're kind of all using the same chest hair, whatever thing they print on, even with the different brands, which is funny. I still have questions about the lamb. There's, oh boy, we have an inflatable pickle. You guys, 36-inch giant inflatable pickle. I'm clicking on it. Only $4.68. That's a good deal. It's a good deal. Oh, you can get a 1-pack. Oh my God. Or a 4-pack. Oh wow, the 4-pack's a really good deal. Only $6.19 for 4 of them. I'm gonna lose my brain. Wait, what was with the child? Why is, oh my God. I don't think this is meant to be a flotation device though. That could be, I feel a lawsuit coming on for a number of reasons with this. I see a lawsuit coming on with this. Because I don't think this is meant to be a flotation device, but also there's a lot of just a lot of things. Okay. Oh yeah, right. I know. I saw the clown. Oh my God. Okay, so you guys, the blow up dolls. Does anybody need explanation about what types there are, or are we all good on like different types and like, you know, on what exists in the world? Oh my God. Wraparound lover doll. Oh my God. Another sheep thing. What the fuck is this? Dead, what? Y'all, there's like rope, duct tape, plastic. Oof, that's not, I don't like that at all. That's not funny or what. And that's just not, that should not be on Amazon. That should not be for sale anywhere, I would say. That's odd. Oh my God. Wow. Yeah, like a murder victim. Exactly. Victim. Yeah. It's whack indeed. So the overall pick, let's take a look at, so we've got the overall pick is this one. Why are the faces so weird? This one's got a name, Diego. Why does he not have any hands or arms or, oh, I guess he does, but they're at right angles. That was weird. The clothing's not included. Well, that's unfortunate. Grow a girlfriend. Drop me in the water for a lover that's made to order. What the actual fuck? Oh my God. It says a girlfriend that doesn't nag or complain. Oh, fucking hell. Toilet golf. Jesus Christ. All kinds of things. Here's a book called How to Live with a Small Penis. Is this real life right now? Okay. Abort. Abort. I'm taking Meg's advice. Abort. That was a detour, guys. That was a detour. Rattler. Yes. Wow. What happened to Twiz? Twiz was here for like 2 seconds. I mean, I'm like just expecting certain. Heather, right in time. Because of blow-up dolls. Oh, I know why. Wait, I was thinking to myself, it's in the document. No. Because there was a question about it. There was a question about blow-up dolls on Amazon. That's why. And I was like, do they even sell those on Amazon? And, you know, there we go. Okay. Excellent. So back to the document. All right. Yeah, but this is just so interesting, right? They just throw that in there in parentheses. Like, if you could have mentioned it sooner, why didn't you? Also, like, what? I mean, obviously they just wanted this to get out into the media, but why did they not do it sooner? Hi, Black Widow. We love you. Black Widow joins us from Ireland. For anyone who does not know, we love you. You were just looking up blow-up dolls on Amazon. You might have missed it. Missed some craziness. Yeah, but again, like, I don't know why they wouldn't have said this sooner. If, like, they can just chuck it in some parentheses. Kohberger's entire click history, items not related to knives and accessories, was not relevant. Without any legal basis, the defendant claims the state cherry-picked specific clicks or purchases without the Amazon click history. I wonder if Santa's just mad because of the thing about the cherry picking, and so he threw that in there as like, you know, being like, what's the right word? As like revenge. But like, that's not how it's supposed to work, right? Like the law. This is simply not true unless you consider seeking only items of evidentiary value cherry picking. Irrelevant click activity on Kohberger's account would not provide any relevant context to, and again, just to read, every time they say Kohberger, remember, it's the household account. So like, it's the whole family, right? Should say like Kohberger family to be accurate. And then again, they said it again. In case anybody missed it, Santa's like, let's do it again. I.e. purchase of a KR knife with sheath before the murders and his click activity, including a search for a knife with sheath after the murders. Footnote 2. Oh, Black Widow has friends here. Okay. Oh, that's beautiful. I love that. I hope you have a good time planting your trees and a nice, so I guess you finally finished the packing, huh? If you're still here, you can let us know, but I hope your move goes well. I know you've been preparing for that for a while. Yeah, pettiness. I would say that's accurate. Got our new Lori Vallow command as well. So here's this footnote. Oh, you guys can't see it. Hold on. All right. The defendant argues that Amazon's recommendation system influences what users see and click on, but this purported use of AI technology is not relevant. Even if an algorithm might suggest certain products to a customer, the algorithm would not cause their customer to repeatedly and over the course of several days browse web pages relating to K-bar knives, sharpener. Wow, they are really just letting their hair down, as they say, with this. Like, just, here we go. We're going to talk about the knife and the sheath and the purchasing of it. Yeah, they just saved it for now, I guess. Where was the footnote? Ah, there it is. Okay. Bryan Kohberger's Amazon.com click activity is relevant and admissible. So under Idaho Rules of Evidence 401, evidence is relevant if it, we don't need to read this. We know this backwards and forwards at this point. That is not the case. K-bar knife sheath with a USMC logo was found next to the victims. Defendant's DNA was found on the K-bar knife sheath on the scene. Applying the test for relevancy, first Kohberger's click activity, which shows a purchase of a K-bar knife and sheath before the homicides, makes it more probable than it would be without the evidence that the K-bar sheath found at the scene was right. So right there, this is the balancing test, right? They're saying, is it more probable, right? Second, Kohberger's click activity after the homicides makes it more probable than it would be without the evidence that Kohberger had a reason to search for K-bar, knife, and sheath after the homicides. But who would be that stupid to do that? Also, I just have to say, who would be like, oh shit, I left my knife sheath at a murder scene. I better go buy a new one on Amazon. Who would be who? I'm going to quote Archimedes from The Sword and the Stone. Who? I'd like to know who. Anybody seen that movie and know what I'm talking about? Because if not, you probably think I'm crazy. I mean, I am crazy. That's fine. Also, that's one of my favorite Disney movies. And there's a really great squirrel scene as well in that movie. And one of my favorite quotes. Okay, real quick. Just one of my favorite quotes is from that movie, and it's from Merlin. And he says, he's talking about, let's see, Arthur's asking about gravity and love. And it's actually the very end of the squirrel scene. And then I don't want to mess it up. So I'm going to just look the quote up real quick. Because like the girl squirrel is crying because he broke her heart. Hang on. Where is it? Wow, that was made in 1963. Crazy. Okay, so oh my God. Literally, you guys, remember I was just saying, who? I'd like to know who. Literally, there's the quote. Archimedes the owl. Literally, there it is. That I was just doing. Oh, that's right. He all says that. Oh, pin feathers, he all says. Okay, I'm looking for. Here it is. Okay. Oh, it's so sad. The girl squirrel cries and it's so sad, you guys. Okay. She's crying and she's in the tree and she's crying her heart out. Oh my God. Merlin says, lad, that love business is a powerful thing. And the girl squirrel is sobbing. And then Arthur says, greater than gravity? And then Merlin says, well, yes, boy, in its way, Ida, yes, I'd say it's the greatest force on earth. I also thought that was a powerful moment. Okay. But yeah, I was saying, like, who would be that dumb? That was the question initially. Oh, I'm glad that, good. I don't think they gave a date, did they? Hold on. Oh, they did give a date. March 20th through March 30th. Okay. I mean, the state would argue that it has to do with buying a murder weapon, right? I think that the defense would say that knife could have been used for anything. I mean, the defense, there's numbers of ways that you can go about handling this. So I'm not even going to presume to say which one the defense would go with first. But here's what I would say. Again, going back to, it's a household account. There is actually no way for them to know who in the household purchased it. To my knowledge, I don't know how there would be a way to know. The only way to see that I can think of that would be, again, based on the device. And that's the one thing that Amazon can't tell. It cannot tell which device was used. It's a household account. Everyone in the family used it. And remember, I said earlier, is the state going to address that? They haven't yet. So we're still keeping an eye out for if the state does address the household account of it all. Heather making a great point here. Only in Chelsea's do we get Amazon blow up doll searches and 5 minutes later, heartbroken squirrels. Yes, that's a fact. That is an actual fact right there. Thank you, Heather. No, and literally, this is the first time we've seen it in any filing, which is what's so wild, right? It's just, they just say it, but we don't know how. It says known. It says when it was known to law enforcement. It doesn't say how. It doesn't, we don't have it. We don't have anything. And even if it arrived at his address, somebody can always, it could have been a family member ordering it and shipping it there. And just, that's the thing, right? Like, there's plenty of ways to pick that apart, I feel like. And, you know, it's going to be one of those things, right, for the jury, like the totality of the evidence, right? You know, I do think if they can try to, if they can show, if it's possible that they can show it was definitely him that purchased it, that will go a long way, I think, in terms of giving the state something to work with that they didn't have prior to our knowledge of. Because, you know, it's just, they don't have, it's just not, it's not a strong case. Obviously, you guys know that. So, okay. So, right. Applying the test for relevancy. Okay. We read that one. Okay. These facts are of consequence to determining whether Bryan Kohberger committed the homicides. I mean, you could just as easily say that because it was, this is just an example, right? Theoretical. Like, let's just say it was the dad that ordered the knife, right? Again, household account. Then does that mean it was the dad that committed the homicides, right? Defendant argues pursuant to Idaho Rules of Evidence 403, the relevant evidence should be excluded. Does anybody, Heather will know, because I could go looking for it, but I bet Heather will know off the top of her head. How long was it between the homicides and him going home for a break, specifically when his dad and him were driving? Let me know. I'm just thinking. Defendant argues pursuant to Rule 403, the relevant evidence should be excluded. Isn't that funny that they said this? Because Rule 403 is like, if it's relevant, it's not excluded. And so that's why the state's being a dick here, basically. The defendant fails to show how this evidence is unfair, confuting, misleading, would cause delay, waste time, or be cumulative. That is because it is none of those things. For fuck's sake. What is clear from the defendant's filing is that the defendant doesn't like this piece of the state's evidence. That is rude. Defendant's Amazon click activity, and therefore would like to keep this piece of evidence from the jury. However, his arguments are without merit. While this evidence is prejudicial, relevant evidence tends to be. It is not unfair. Thank you, Heather. He left on December 13th. Okay. I was just thinking, like, what if, I was thinking if there was, if the proximity of the dad being there was closer in time to the murders, there could be a way that one could try to make the argument that maybe it was like, especially because there was all that confusion with the dad trash DNA, which we talked about before. And I was like, There was a point where I actually thought maybe it could have actually been the dad's DNA on the knife sheath. And it was kind of unclear. And then we just sort of conceded that it had to be Bryan's, but no one really conceded that and stated that. Anyway, like if the dad had been up there earlier, right? I don't know. It would just, it would add to the things that you could do as a defense strategy, right? Especially because their DNA would be so similar, right? And I wanted to make a correction. Rule 401 is the test for relevance, not Rule 403, which I know I just got all excited. So, cost long to get the sheath delivered in snow, Google. Yes, excellent. Love that. I love that so much. That's a good question. What did Google say? Let us know. And the timing of when he left might be based off of when the car is pulled over. I don't know. Let us know, Heather, what you think. Okay. So, okay. Then there's the footnote here. The defendant touches on the issue of identifying the account user making the Amazon search inquiries as shown by the click activity. The state recognizes that the activity of the user making the inquiries is relevant, and the state intends to rely not only on the click activity, but also other circumstances to connect the defendant to the original knife purchase. This is a really confusing and long run-on sentence. Let me read this again. The defendant touches on the issue of identifying the account user making the Amazon search inquiries as shown by the click activity. The state recognizes that the identity of the user making the inquiries is relevant, and the state intends to rely not only on the click activity, but also other circumstances. What other circumstances? To connect the defendant to the original knife purchase. How? And subsequent search injuries injuries, inquiries for our replacement knife and or sheath. This is literally what I was saying, right? They're not saying the thing about the household account, but the question that I had is like, how are they going to prove it was him, right? So this will include the defendant's financial activities, the click activities vis-a-vis other events, such as the homicides, a related purchase activity connected only to the defendant, right there. We don't know what that is, but this is what they are saying this essentially as to how they intend to prove this was him and not another family member. Now, what a thing is that's connected only to him and not another family member, I don't know. How are they going to prove that? I don't know. We don't know what the thing is. And testimony from witnesses with knowledge that the defendant purchased a K-bar knife. Huh. Who is that, though? That's what they're saying here. They're not mentioning the household account, which they should. They should confront this head on. But that's what this is addressing without saying it point blank, is that how they intend to prove it was him, basically, is this. We'll see if it's successful or not. Time will tell. Won't it? Okay, so Heather is saying it seems he left late on the 13th. Okay. Right. So she's basing that off of when he was stopped in Indiana. Got it. All right. Yep. Makes sense. I figured as much. So so essentially no one has said proof that he was leaving on the 13th, essentially, right? Like, for example, what I mean by that is we don't have the Cellbrite report. We don't have, here's the cell activity showing he left. Like, that hasn't been in any filings. And I don't even think it's been, I mean, I didn't know that it would be necessary. It was just for our own edification, right? But it's more like it can be deduced because of what we know from the other things, like we were saying. I mean, literally, it's entirely fucking possible. Amethyst Nora, also welcome again. What if the dad bought, I mean, yeah. And people can buy things and then let someone else borrow it, right? Between family members, which would just, again, that's the lines that I'm thinking along too. When you think of the household account, how do you, room for reasonable doubt, right? Like, not only is the household account a shared account, but like, because it was so many months prior, what was it, 9 months prior or whatever, March, like, it could have belonged to one person in the family and then they gave it to somebody else. You know what I mean? And then the other person's DNA would still be on it, right? As an example. I'm just throwing out things, there's just, yeah. When you've got the household Amazon account is really important, I think, because if it wasn't, you have less room to work with there. Oh God, not this again. Really? Oh God. Is that what this is? Is literally just the affidavit again? Is there anything else in addition? Oh, just the search warrant. Okay. Yeah, no, and now I remember, I already looked through that. Yep. All right. We're on to the next one. Guys, this is this is going to be really exciting. Are y'all ready? Are y'all ready for this? There it is. Well, so they would try to look at your bank records and see, but again, if you just use a card, that's where the household account matters. If it's just your account and your bank records show you purchase it and it's like through your account, then I think that they would know. But if it's a household account, like with Amazon or other things too, right? You can have like multiple cards on file. You could have, if it's a household account, there will be multiple cards on file. It'll be other family members' cards. So that's why I think it makes a difference, because if it's a household account, even if they pull up the payment information and it says the payment information is like your name, you could easily argue that it could have been clicked on by another family member because all of the accounts are on that, or all the cards are listed in that one account, right? So I think it just matters. Like if it's a family account and then each person has several cards, that could be like what, 12, 16 cards on file for the Amazon account, Are you telling me PCA page 12 or somebody else? Yeah, the order receipt, right. Well, I would assume they have it. I mean, that would exist. Like that would exist. Now we don't, of course we wouldn't see that yet. It's the first time they've even referenced it in a court filing, right? Like that. So, okay. Gotcha, Heather. Got it. Got it. All right. Suspect vehicle, guys. For any of you guys who are newer, I have done a lot with the maps and the timeline of all this. We may end up pulling those up. I've been meaning to do a follow-up live stream for the maps, and actually I have had a couple requests to do that anyway. But I do think we're going to get some more. Oh my God, Heather. Do you think they brought, okay, first of all, so Heather's asking, where did Twiz and Kane go? To the tub where there's grow a girlfriends, and then maybe to a pool party. And I was literally thinking, do you think they brought the blow up pickle with them for that? Oh my God, I'm dying. Y'all. And that's why I was like, clearly, I'm like, something happened, because they would be totally saying stuff like that. It's a shame they missed that. It's like a fucking shame they missed that. Now it's like, we can't recreate that moment, right? It's like that moment is gone, and like they missed it. And I'm so bummed that they fucking missed it. And then like Heather said, we went from that into like the crying, heartbroken squirrel. But anyway, yeah, so the maps. So maps. Okay. I do appreciate that they still call it suspect vehicle, that they still don't feel bold enough to call it the white Elantra, because that's flying too close to the sun. You know what I mean? It's a bridge too far. Let's just call it a suspect vehicle, because, you know. All right. Some of this is old news. We're not going to read the old news bits. We know about the voices or whimper, all the dog, whatever. Okay. And again, this is another opportunity, which I will take the opportunity here to reiterate, that no one ever saw the suspect in the residence or whatever, right? Leave through leave through any door, let alone a sliding. Like that was added in the PCA as that was law enforcement narrative. The walking towards the exit just means walking in that direction. Again, they're still kind of trying to inch their way with it here. Okay. So the King Road video, sorry, the 1112, just to be more specific, the 1112 King Road video shows a white sedan entering the crime scene. And we saw that in the initial filing, and you guys, it was terrible, and it did not look like an Elantra, that we could tell. So, and not that we're experts, but the features on it, not even close, right? Are you talking about the text message document one? Are you in Japan? That is depressing as fuck, though. I'm not even gonna read that because that's really fucking depressing. But yeah, are you talking about the text message document? The one we read earlier. Okay, so it shows a white sedan entering the crime scene. At least they're not saying a white Elantra. Well, now I have got a problem. This same white sedan is seen departing the crime scene. Well, it was the same camera, right? I mean, you can barely fucking see it at all. I don't know how they can say it's the same sedan. I don't know how you can say it's the same sedan or that it's an Elantra. Either of them. Okay. So I guess my question was, are you referencing things in this document? I guess was really my question. So based on this information, investigators focused on identifying the make and model of the white sedan, hereafter suspect or questioned vehicle. We even heard them say it that way. Seen on the 1112 King Road surveillance. The suspect vehicle is seen on the, okay, right, the same surveillance. Prior to the homicides, it makes 3 initial passes at 3:30, 3:33, 3:38, 3:40, 3:56. I'm going to highlight this. I feel like we're going to need to come back to it. So I'm going to highlight this so we can easily find it with our eyeballs. Bam. I'm going to highlight this too. This is great. Y'all that have been here know how I do with the timeline and the maps. This is great. I'm going to get to flesh this out. There's going to be some work to be done to add all this in. I'm really happy to just get information, because whether it's accurate or not, because again, the way you can prove it's inaccurate is by using the other information, right? So, and that's why I have the master list color coded. And by the way, for anyone who is interested, that is in the Discord, probably posted in several things, probably posted in documents, but also, or scroll docs. And also I'm sure it's in the Idaho thread. But it's going to be getting some updating. So, all right. I'm not going to read all of it because I think it doesn't matter until we can come back to it, right? It's going to matter, but it's out of context here. So, okay. FBI report Special Agent Rob Hill. I almost said balance automatically. We got some maps attached. Investigators were able to write literally as I just said. So basically that's the information that is in the exhibits, which is maps. Yeah, we're going to use it in conjunction with a map. Investigators were able to review this in those videos to determine the route of travel. Investigators provided video footage to the FBI to determine the year, make, and model of the suspect vehicle on that surveillance. Let's see. Oh, there's Agent Imel reviewed multiple videos and still images. According to Imel's report, quote, the multiple submissions of media were reviewed independently and collectively to identify the question vehicle's make, model, and year. So what that means is individual people identified it, and then as a group, I guess. FBI report of Special Agent Imel is attached, I guess. One of those videos, the 1125 Ridge Road video, provided a clear view of the suspect vehicle. And it looks like it should be attached, hopefully. Imel was able to compare this video to the 1112 King Road. This video was captured at 4:01 a.m., approximately 3 minutes prior to all of this. Honestly, is pretty much useless until into my brain until I can get it on a map, right? With the timestamps and with the location and with the map, because this is just words to me at this juncture. But don't worry, we will do it with the map. Okay, this part though matters in terms of just the words alone. So here we go. So his opinion. The question vehicle shares similar class characteristics with a fifth generation Hyundai Elantra between 2014 to 2016. The similar class characteristics include, but are not limited to, the overall body style, window configuration, front grille configuration, headlight shape, side trim, rear brake light configuration, rear license plate position, rear bumper position. The position of the rear bumper reflector and shape of the fog lights assisted in narrowing the vehicle span. Are they just leaving out the part where it was different years though? Oh, I guess so. They're only including that part. Oh, dear me. Dear me. Okay. Yeah. Are you actually making maps, Heather, or are you just collecting the info? See, the thing is, like, at least I saved all that shit. I saved all my work. For the map, so that, because I knew I'd be going back. So I'm glad I did, because yeah, and for some of you guys who maybe haven't seen, and I've been overlaying the maps with like the pane drawing and then like where the cell towers are and stuff. It's pretty helpful, I think. So argument. The state's expert regarding a vehicle identification, Anthony Imel, should be allowed to explain to the jury his opinion that the suspect vehicle shares class characteristics similar to a fifth generation Hyundai Elantra. What about the other years though? Dude, this is crazy. Don't. You know you can't talk about this without first talking about the other fuck-ups with the ears. Anyway, he can't hear me. He being Santa. The suspect vehicle was identified from surveillance footage from the area of the crime scene. The defendant claims that the suspect vehicle was not identified from surveillance footage in the area of 1122 King Road. This is simply not true. Oh my God, that sounds like Ashley Jennings. Did she write this? This is simply, I can't even do an impression of her. That is simply not true. You guys can all imagine it in your heads, I'm sure. As stated in IML's report, multiple submissions of media were reviewed independently and collectively to identify the questioned vehicle's make, model, and year. So this vehicle was picked up on, oh my God, look at this map. Look at this map. Oh my God. Sorry, I'm excited. Like, oh, wait, so we do know how to use proper maps? Like, what are we doing then? Why didn't we do this? I mean, I know why. It's a rhetorical question. For fuck's sake, though. Look at this. Oh my God. Beautiful. Okay, well, now I'm going to be redoing my maps. I'm super excited. Oh my God. I'm going to save all. I'm just zooming out to get the full picture. This is beautiful. Whether it's correct or not doesn't matter because, again, we're compiling it to everything because that's how you can prove when things are wrong. So, or what's missing or what's, all of the things, discrepancies, what have you, or what is right, what is correct. I don't even really care about the text because they're just describing what they're going to show on the map. That's what matters. Look at that. So we're going to do a whole other live stream with maps, guys. That's what's going to happen. Wow. Interesting. I'll have to see how this matches up to the route that I ended up thinking they were suggesting here because it wasn't clear what they were suggesting, right? Until now. Now they're making it clear what route they're actually suggesting. There does not need to be continuous. So that was one thing. Yeah, the continuous footage. There does not need to be continuous footage for this evidence to be admissible. Defendant argues there's no continuous footage linking the vehicle at 1112 King Road and that from Ridge Road. Defendant's argument appears to suggest that because every single business and residence surrounding the crime scene did not stop. You do not have to be rude. I'm talking to whoever wrote this, Santa. They didn't suggest this. Come on now. Don't make me go, please. Defendant's argument appears to suggest that because every single business and residence surrounding the crime scene does not have video surveillance, that's unreasonable and it's just really immature to say. The state should be precluded from introducing this evidence. This is illogical. Well, I think what your argument is illogical. If there's a valid way for you to look, if there's a way for you to argue against what they're saying and do it in a proper manner with a different valid legal argument, you can do that. And the fact that you're not doing that is interesting. Like, why are we acting like a toddler throwing a fit? I can't. As argued above, the state should be able to introduce all captured video surveillance surrounding the crime scene and preceding the homicides. Not after, I guess. I don't know. The state's expert should be able to opine based on his analysis and surrounding circumstances that the surveillance is picking up the suspect vehicle. This opinion would not be speculative, as argued, but instead based on logical, educated inferences from their view of surveillance. They're completely, I feel like, ignoring the defense's argument. Now, I appreciate that they're finally including fucking maps, but they're not actually addressing what was stated in the defense filing, apart from mocking it. That's all they're doing so far. The identification of the suspect vehicle is relevant and admissible. As the court has seen in the defendant's other filings, the defendant tends to label bad evidence for the defendant as irrelevant. Pardon? Hold on. Let's just do this real quick. I can't with it. This is so I don't go. I'm just going to do it this way. Let me pull this up. All right. So this is the defense filing for the make and model of suspect vehicle. We're going to do a Control F myself. They put it in quotes. They put it in quotes. In their filing, in the state's filing, they put it in quotes. Bad evidence. They put it in quotes. 0. 0. I don't even know that they use the word bad for which one could use for anything. I don't even think they use the word bad. Look, nope, none, not even once. All right. Oh, oops, hold on. Jesus Christ. Okay. Do you see why I did that here? You guys? The defense they say tends to label as if it's like not literally, but figuratively, but then they put it in quotes. Bad evidence. The defendant labels things as bad evidence. The word bad, even without evidence, is not in the filing at all. Oh my God, I can't. I'm getting a headache. For the defendant, and I honestly don't even get headaches. This is like just as irrelevant. Now this court to prohibit the state from introducing it. This is not the rule. Oh my God, I hate this so much. Evidence is relevant. We know what it is. Rule 401. Let me take a break and look at the chat. For sure, right? Wish they would have saved their work. Yep, or do. Yep. Okay, so that's Heather's building a list of all the stated times and all the docs. Oh, good. And mapping. You're mapping what now? Did you finish that thought, Heather? Because it looks like you were going to finish your, what are you mapping? What are you mapping? Where was this from, Heather? Yeah, it doesn't surprise me. Again, it's so funny how everything tends to connect back to the dad, doesn't it? And it's weird. That's why I was asking that question about what time, when they drove, because it is odd. This doesn't surprise me. Whatever this is, it's all in one thing here. If Mr. Kohberger's father's account, like, so, and it says Kohberger and his family. Yeah. So, you know, Heather, you're going to drive me crazy. Can you tell me what you're mapping, please? Oh, okay. Yeah, we haven't covered that one yet. Thank you. That's why. Yeah, we have not covered that one yet. I was thinking I was going to get to it on this live stream. I think it'll be on the next one. Yeah. Yep. Thank you. Yeah, I haven't read all of the documents yet, obviously. There's like a bazillion. Yeah, and the dad trash. Don't forget the dad trash. You're mapping the footage. Okay. Okay, so the defendant fails to show, oh my God, this is just substantial. So the balancing test there, blah, blah, blah. The state anticipates Mr. Imel will testify in accordance with his expert opinion at trial. The state anticipates other state witnesses will refer to the vehicle identified on surveillance footage as a white sedan or other like language. White car. I mean, again, they're not calling it an Elantra. Like the reluctancy to say that it's a white Elantra, right, is interesting. The jury should be able to hear Mr. Imel's opinion regarding the make and model of the specific vehicle. I mean, the reason they're not saying it is because it's not, you can't say for sure, right? It's going to be a fact for the jury because you can't really tell. That's the point. It's going to be up to the jury to determine. And that's why this testimony matters, because it's going to be an expert trying to say, yeah, you should believe that this is a white Elantra. If it was, this is like so subjective, right? And again, that's why they're not calling it in any of these documents. They don't say white Elantra, they're saying suspect vehicle. All right, so weigh this information with other testimony or other evidence admitted, and then decide if they believe the vehicle. Yeah, literally what I was just saying. It's going to be up to the jury to decide if they believe it is. I mean, that's true. That's a factual thing. The jury will have to decide for sure if they believe that it's a white Elantra. That's true. I do agree with that. They will use this I agree with this. They will use this information to ultimately determine if the same vehicle was the defendant's Hyundai Elantra. Yeah, yep, that's what happens in trial. And then there's their conclusion. Let's see what else they got attached here. And well, I literally was going to say, please don't tell me it's another freaking Brett Payne, but it is. This thing is like, we can't get away from it. You know what I mean? It's just like haunting us. There's the shitty ass maps. So we know this. We know all this. There's his stupid shitty ass map. All the dumb shitty maps. Okay. So, and see, this is why I love it, right? Because literally in the document we just read, it said 2014 to 2016. Like, and remember when I lost my mind, one of the times that I lost my mind, and I was like, are we just, the state has to know they can't just leave this part out. They can't just leave this part out. Why are they acting like everybody is dumb? Not just acting like the defense is dumb, but also like we are all dumb. Like, huh? Like, duh. Come on now. Jesus. Right? Okay, so here's this. These are the ones that were on the maps. It's just, this is just certifying or whatever you want to say, that it's verifying that the camera times were. Oh, interesting. I was going to say all accurate to local time because most of them are, but that's not true for all of them. So what I want to know is this. Oh, interesting. Heather, what did you think of this? So in other words, on their little maps, did they update it to the correct time? Did they count, or did what, like, okay, let me highlight this. No, not, oops, didn't mean to do that. Like, did they go ahead and do that conversion? So camera time, approximately 1 minute and 43 seconds behind local time. So did they correct it already? And then this one is interesting. Camera time, approximately 5 seconds. Oh my God, why? Literally, I don't know why it just chooses to do things differently sometimes. All right, so it's going to highlight it like that for a second, I guess. Approximately 5 seconds. I thought it was going to say 5 minutes. 5 seconds is, I swear to God, dude, so stupid. This is so dumb. Can we dude, Adobe? Okay. Look, let me just do it this way. Okay, stupid. I'm just trying to highlight this. That's all. There we go. There we go. That's all I wanted to do. So yes, let me see what you're saying there, Heather. Okay. Well, but I mean, is like on the maps that we already saw where it had timestamps, did they already do that math? Did they already convert for the error on the timestamp or not? Okay. So this one's behind or wrong. Just time is wrong, right? Okay. That one's wrong. Where'd it go? Okay, here it was. Accurate to local time within 1 minute. Isn't that the same as being 1 minute off? But it's not going to say ahead or behind. That's odd. All right. Well, okay. That's also behind. Dude, the stupid Adobe just drives me crazy sometimes, you guys. Okay. It just doesn't. Okay. So these are all not accurate. Oh dear. For visual representation of the sightings listed below, maps have been provided as reference documents. For the Indian Hills addresses below, please refer to map 1. For the remainder of the addresses in Moscow, please refer to map 2. Okay, you're saying we don't know that yet. Okay. So just to, I'll come right back to this page. I just want to show you guys about why I'm asking the question I'm asking. So let's find one of these maps. All right. Here's why I'm asking the question I'm asking. So when you look at these maps, I'm like super excited, like, yay, new maps. See all these timestamps, right? All these timestamps. So the reason, and again, we're going to work on the map. So the reason I'm asking the question I'm asking and is because so many of these cameras, the timestamps are off on the cameras. So the question then becomes, is that when we're looking at those maps, does it mean that they already went ahead and subtracted the 1 minute and 43 seconds or whatever the case may be? Or is it with the wrong timestamp? But they didn't say, which is just, I don't even know. I can't wrap my head around that. God damn it. That sounds like an Ashley Jennings quote. Didn't mean to do that. Okay, sightings. Okay, the surveillance review. You got to be kidding. Is this a joke? Like, okay, the first one says a vehicle matching the description of vehicle 1 is seen driving westbound on Indian Hills Drive. The next one says, summary, the headlights of a vehicle. You're joking. You guys, the headlights of a vehicle are seen drive. Help! Help! The headlights of a vehicle. Pardon? Is this a joke? A vehicle matching the description. At least we're better to reality here, right? When it's like, at least it matches vehicle 1. I mean, there's problems with vehicle 1, but at least they're matching, or they subjectively think they're matching. Like, that's better than this. You gotta be kidding me. It's like saying, where did the crime happen? On planet Earth. Great, thanks. That narrows it down. Excellent. Job done. Oh my God. Oh, okay. So here's the thing. So we've got, interesting. Okay, so we've got the camera times. We don't know yet if they went ahead and calculated, okay, for the difference, the discrepancy. But we have the camera time. And then we have, this is a record, interesting. Okay, of all the surveillance. So this is going to be so fun. I see, and I know Heather's doing it. I'm going to be doing it too. Going through and trying to match these up. It's going to be, I'm going to have to do it. I'm going to have to do it not while I'm live streaming, obviously, so I can put it all together. But that's what's going to have to happen next. Do these, like, wow. And the other thing is it's like, there's going to have to be probably 2 sets. Maybe there needs to be 2 sets. One where you don't account for the difference in time, and one where you do, because we don't know which one they did. Heather, did you think of that? Or are you already doing that? Okay. Does this go on for 51 pages? Is that what the rest of it is? Oh my God, there's so much of this. Let me zoom out a little bit. Oh my God. They're still going. They're still going with all the sightings. Now, I don't know that all of these we will need. I mean, I don't know. I'll have to just see. I'm just saying it may not be. Well, I don't know. I feel like I'll probably just go ahead and plot all of them because that's how I roll. Oh, here's another. Whoa. Okay. What do they got here? What the fuck is that? Okay. So what I'll be able to do, guys, is I'll be able to take this and flip it so that it's not, so that you can read it. I'll be able to do things with this. Let me just put it that way. This is great. I'm glad we have this. We are going to do things with this, and we are going to implement the other things that we've done, and we're going to put it all together. And yeah, that's what we're going to do. because these are not very helpful right now, right? I'm going to save all these separately, and yeah, it'll be great. This is going to be awesome. I'm so glad we have more things. We're going to do a great follow-up on the maps. So what the fuck is this? Oh, okay. So title, unknown subject, Moscow Police Department assistance, and then it has the victims' names. Oh, these are the video files, okay, of the suspect vehicle. I think that's affirmative there, Heather. I think that's affirmative. Oh, good question here from Too Fast. Can you custom order one with 2 boobs on the front and 2 on? I'm sure you can. I'm sure you can. Anything is possible, right? Don't ever doubt. Too Fast. Don't ever doubt. Anything is possible these days, right? Okay. Okay, DVDs. They're using DVD. Oh, okay. Look at this. Again, all of this we will. Oh my God. I can't wait to make this usable to see what they're relying on. Make model chart number 3. I love how what they didn't do is get an actual Elantra. Okay, you guys. Because I'm thinking, how would I do this if I were doing this with using rat logic? Literally what I'm thinking is this. You know what I would do? I'm thinking to myself, I would get whatever the year, again, they're all over the place, right? But whatever year they're alleging they think the car is, right? Or get all the years. Get one from 2011, one for each year, right? Not that hard. Get them, go at night and drive literally where these cameras are, and literally see if you are driving there at night on the road, like, does it look like this, right? Like, you know what I mean? It's just something I would do if I could. Just seems to make sense. Oh, and that's the end of it. Jesus Christ. Oh, hello. So I don't think there's a way I can like flip this until I do my things with it, which is like take it out and then do things with it. That's what she said, doesn't it? What does this do? Oh, you 1 page at a time. Yeah, so I'm going to have to, I doubt there's a way to, yeah, I'll have to do it that. I'll have to take it out, take it on its own and do it, which is fine. This is great. Let me save my changes. We're going to be hard at work over here, guys. I mean, we're always hard at work. We're going to be hard at work on this with the maps and everything. Okay. Saved. Yay. The blow up doll. I'm so glad that came up. See, now we have the blow up doll with the 22 seconds. Oh man, it's so good. It's so good. Yeah. So let's do one more. Let's do let's do this one. This will probably be our last one for this live stream. So this is the defendant's objection to the state's motion to eliminate 911 call. Wow, that was Silent Night. I didn't even mean to do that, guys. Oh God. Okay. The state correctly recognizes the statements on the 911 call are hearsay. I personally don't think they are hearsay. That's my personal opinion. Personal opinion. Idaho rules of evidence make hearsay inadmissible unless it meets with an exception. The state identifies 2 exceptions to the rule against hearsay and further recognizes all parts of the statement must meet the exception. The state must provide foundation for an excited utterance. The state alleges that statements fall within the excited utterance or present sense impression exceptions to the hearsay rule or are non-testimonial. The state distinguishes and identifies only one statement but claims the rest of the statements fall within the exception of present sense impression. So we do not need to, we've read all of this. We know how this is. This was in the other filings. So we're not going to read all that. We'll read this part. This 911 call did not come at 4:30 in the morning when DM and BF communicated with each other and ended up in the same bedroom. This 911 call came 8 hours later. This call came after DM and BF each made calls, corresponded through text and other messaging to family and friends. Then a 911 call came only after friends arrived. Don't worry, guys. We're gonna take another look too at the one with the text messages. I have highlighting and all kinds of stuff on that. That's going to be another one that we're going to be coming back to a lot. So, yeah, we're not gonna pull. We covered that earlier. That was the first time I've seen it, but we're going to be using that regularly, I'm sure. BF initiated the 911 call, and thereafter the phone was passed from person to person. The state lays out only one statement as an excited utterance. The statements of EA when the phone was passed to her. Oh, they saw some man in their house last night. Yeah. The state claims that these words are an excited utterance because they explain why Xana was passed out. The state fails to take into account why that statement was made. But, I mean, passed out isn't even accurate, right? I mean, that's a whole other thing. That's a whole other thing one could be like, hey, it's not like, for example, why would I say that this is not hearsay if you take it statement by statement? Because she was not passed out. It's not being offered for the truth of the matter asserted. The truth is she was not passed out. She was dead. Anyway, the same transcript and same page reflect the dispatcher asking exactly what was going on. EA stated, one of our roommates who's passed out, she was drunk last night and she's not waking up. Again, it's still like, I guess the drunk part could be accurate, but after that prompt, EA told dispatch about the man they saw. Thereafter, the phone was handed back to DM. The statements by EA do not fit within. Oh, I see what they're saying. That's interesting. That's not okay. The part where it's bolded and says they, I don't think that's part of what they're arguing about with the hearsay, but that is interesting that they're making sure that we notice it. That's what the point there. That's not relevant to the argument. That's like one of those little, remember when I said, guys, there's these little things that they're doing that they're getting really bold with that they have been less bold with before. I mean, both sides, which is like putting things in the filings that are really for the public. This is an example. Because it says they saw. They want to make sure that we're noticing that. So they saw, as in the man was seen by both girls, DM and BF, I guess. I mean, of course, you can all say they. Sometimes you can be referring to a person, and a person can be singular, can be called they. But anyway, so they're drawing our attention to that. Thereafter, the phone was handed back to DM. What is ad hominem propaganda, Heather? I mean, there's a lot of it, but like, the they part, I don't think is what you're referencing there. The statements by EA do not fit within excited utterance exception. She first states she is reporting a roommate who passed out from drinking and not waking up. She then states they saw some man in their house. EA does not have first-hand information and is repeating what DM and BF told her. All the statements made by BM and BF must be analyzed under the applicable framework for excited utterances. So they're going to have to take this statement by statement. And Mr. Kohberger's response to the state's motion to eliminate text messages and testimony, he objects in part based on the completeness. Right. Actually, that was entirely their grounds. I mean, but also because a more complete record weighs against the state's motion. The phone activity of the DM and BF, for fuck's sake, though, guys, of the DM and BF. Again, why it matters is because literally the adding the word the where it doesn't belong changes the context of this to where you could be thinking that they're referencing a direct message. Like of the DM sounds like a direct message. It's a person. I swear. Phone activity of DM and BF shows the statements on the 911 call are not an excited utterance. Footnote 1. Oh, they've incorporated the text message exhibits by reference. Okay. The phone activity is more extensive than a few messages before. Yeah, it surely is. Phone activity did not stop once they were together. Nope, it did not. It did not begin right before it. Nope, it did not do that either. The phones, yeah, we read it already. The 911 call was not contemporaneous with DM and BF's stated awareness of something happening in their house. 8 hours passed until they called for friends. So the reason this matters, again, it's not just when you read this, it's like, yeah, it's weird. Everyone knows it's weird, right? But the reason they keep reiterating it in this document is because it matters with the acceptance to hearsay, right? In terms of present sense impression, has to be present. An excited utterance is a statement that is made while under influence, and an excited utterance, right? There's similarities but differences. So an excited utterance statement that's made while under the influence of an event. The 911 call and statements contained therein came after conversation. Yeah, other activity. And then here's the present sense impression part of it. The state claims most of the statements in the 911 call meets the present sense impression exception to hearsay. They define it again. The only possible statements that qualify are those regarding Xana being unresponsive. Statements regarding what DM and BF claim they saw 8 hours earlier are not contemporaneous in time. Yeah, that's true. Yeah, I know what ad hominem is. I was just asking what you were referencing. It seems like you were referencing something, but I was talking about the word they, and I figured you must have said that. I know what I know what ad hominem means. I'm sure of it. We use that all the time. So, but the part that I was reading doesn't match with what ad hominem attacks are. Okay, so reviewing the grand jury testimony shows the state misplaces reliance on at least some of the statements about Xana. The state ignores previous sworn testimony when it claims the 911 call contains present sense impression because the declarants were observing Xana. By the way, guys, y'all feel free to ask any questions too if you guys have them of any things in here. I try to explain stuff as I go along, but sometimes I don't want to be redundant. Oh, gotcha. Okay. In general, gotcha. I figured. Okay, just in general. Got it. Okay, so the state has not identified what exception to the rule against hearsay applied to which statements. Like I said, they're going to have to go statement by statement, and that's why, right? And what do I mean by that? So again, there's two main things that the state is using. They're using present tense impression and excited utterance. Now, if a statement's not offered for the truth of the matter asserted, it is not hearsay, and then you don't need an exception, right? So the point being that some of the statements might qualify as an exception, right? But then it's like, which exception? So you're going to have to go statement by statement to be like, is this hearsay? And if it is there an exception? And if there's an exception, which one is it? Does it meet the standards? Is it, again, and here the state is suggesting presence of impression or excited utterance, and they didn't specify, and they're going to have to go statement by statement. We've seen this in other cases all the time. Review of the record and background show neither exception applies. The state relies on the conclusion reached by Judge in denying Mr. Kohberger's motion to dismiss the grand jury indictment. Mr. Kohberger disagrees with the conclusion and the state's reliance on the findings. Judge's findings do not include a full analysis of the applicable exception accompanied by the background. Right, because Judge didn't have all that. He just was given, I guess, that little snippet that the state put in their initial filing that we read. Seems like. I mean, we don't know because grand jury and all that, right? This court is not bound by Judge's ruling. The law of the case doctrine applies where an appellate court. Okay, we read this in another filing too, where they're like, you don't have to, you can do something different here. Judge Hippler is what they're saying to Judge Hippler. The court, as the trial court, has the discretion to change its own pretrial rulings, especially evidentiary rulings. Confrontation. The 911 call contains little that fits within the exception to the rule against hearsay. The statements that they saw a man in the house are testimonial in nature. Witnesses will need to be in court to satisfy the constitutionally protected area of confrontation. What does that mean? That's a Sixth Amendment right that you have to confront your witnesses at trial when you're a criminal defendant. So you have the right to confront your witnesses, and that is really comes down to, what does that mean? Cross-examination. That's how you confront them. It's like, you don't confront them being like, hey, yo, what are you saying? Y'all, I'm losing my mind. But it's like cross-examining them, like a feisty cross-examination, for example. Transcript. Mr. Kohberger raises the same objections to the, how was your breakfast bowl, by the way? Too fast? To the transcript being admitted. If the transcript is admitted, the court should only admit a version that is certified by a court reporter. I agree. There is no question about that. Mr. Kohberger has a certified transcript prepared, and it provides an exhibit. Oh my God. What? Is that included? Oh my God. It can't be, because we're almost done with the document, but maybe we'll see. And provides it as an exhibit to this motion. It might be sealed. Anyway, we'll look. Fingers crossed, fingers crossed. Okay, it's separate. Let me take a look at the thing here. Because I know there was a lot of stuff that was allowed to be, well, not a lot, not as much as it used to be. Which one is this, though? Okay, hold on. So there's an order sealing exhibits. I guess it's all of the exhibits. Yeah. Order sealing defendants' exhibits in support of their objections to the state's motions in limine. So why are they sealing that, though? Why are they sealing the 911 call transcript that's been done by a certified court reporter? Why? Why? And who wanted that to, hold on. Hang on. So okay, hang on. Can you guys see that? Okay. Motion to file defendant's exhibits in support of their objection. So the defense wanted it filed under seal. They have, I'm kind of shocked. I mean, I don't know if shocked. I'm disappointed. I don't know what I am. Like, basically, y'all, they have a certified transcript of the 911 call, and they want it to be offered they wanted it to be offered under seal, and that was granted. But not just that, it looks like all of their exhibits for any of their objections to the state's motions in limine. That is awesome. I'm happy to hear that too fast about your breakfast bowl. Excelente. Y'all, how do you guys feel about this, though? I mean, I don't know. I mean, they have that right, obviously, but still, it's like, generally speaking, the way it's been is the defenses have been like trying to get that shit out for us to, to the public, right? And transparency. And I don't know why, especially when, from what we have, the 911 call looks like such a complete and utter shit show disaster, right? Right, guys? Like, it seems like, why would they not want us to have that? I don't know. I was going to pull one other thing up. What was I looking for? I guess that was the thing. And that's why that objection came out later, because yeah, redacted. Wow. Yeah, there you have it, guys. That's a bummer. What do you guys think? Have y'all let me know your thoughts on that? All those exhibits. I mean, but especially the 911 call transcript. I just find that so surprising. What is this one? Riley Nolan's affidavit. Well, we're going to cover that on a different one when we cover the other DNA stuff. Yeah, all of their exhibits are going to be under seal. That's dumb. Right? It's a craziness. So today we have another Karen Reed hearing. Speaking of crazy cases, we have another Karen Reed hearing. So I do plan to cover that tonight. We may, I don't know. It just depends, right, on what happens. Like, depending on how long the hearing is and stuff, I may not have a chance to do another BK live stream today. We'll just see. We'll just see how it goes. And again, it just depends on how long the hearing is. But if we can, we will get some more of these documents under our belts. And we will also, of course, cover that Karen Reed hearing as well. So yeah, and again, for anyone that missed it, we did also have a hearing earlier. Oh my God, y'all. We did have a live stream earlier with the first couple, whatever, like 5 or 6 documents. That's the one where I saw my first look, right, at the text messages and stuff, right? So that was a big one. That was on that first live stream from a few hours ago or whatever. So yeah, I think we all learned a lot about blow-up dolls, squirrel quotes from Disney movies, and I have a lot of questions about in a lot of different areas right now. So yeah, interesting. It's a lot to digest, isn't it? It's a lot to digest. So, but I think that will be it for this one, guys. As far as I know, Turtle Boy and Karen Reed have a hearing thing initially together at 9. So I don't think because Turtle, what was it? Let me pull it up. I'll just tell you guys real quick. It was a thing that Turtle Boy said. Hold on. I'll just read it to you guys. So it was, and when we do the Karen Reed live stream, we will also cover the Proctor documents. Okay, so it says it's from Turtle Boy. Tomorrow is going to be interesting. Karen Reed and I will be sitting together at the defendant's table in the main courtroom at 9 a.m. in front of Judge Doolin. Hank Brennan is interceding in my case for a Rule 17 motion for my phones. After that, the hearing will move into the small courtroom for a motions hearing with Auntie Bev. So after that, so they don't know what time. So, but what's interesting is the Rule 17 motion. He's interceding. Real quick, let me just see. So Rule 17 in Massachusetts governs summonses for witnesses and the production of documents. Kind of like a motion to compel situation. It outlines the process to summons things and compel them, including like the production of evidence. So he said, anyway, well, Alan Jackson is interceding. We're going to save that for when we get to Karen Reed. Let's just do that because I can only handle so much at one time with this stuff. Okay. My concern is like whatever it is that is going on in that, my concern is that Judge Bev is going to use it a certain way. And you guys, I'm sure, can imagine what that would be, right? Because there's been a lot of those allegations made by Bryan about them helping each other out and all this business, right? And it was one of the reasons why she denied admitting Mark Bettero per hoc vice. But also it still carries on as they talk about the witness intimidation bullshit. So And when I say bullshit, I mean like how last time Allie and Jen McCabe blurted it out in the trial and implied that Karen Reed was behind it. So anyway, I just worry that Alan Jackson showing up at all could be a thing that Judge Bev will latch onto. That's my concern. Just to summarize that. How many motions in limine has the state filed? In BK? How many motions have they filed? As in like initial motions? Let's see. Sometimes they're out of order, so I'm just going to see. So okay, 1, 2, 3, 4, 5, 6, 7. I think that's it. Yeah, I think that's it. These are responses. Yeah, 7. I'll double check. I think it's just 7 though. Tonka, if you're just talking about for BK for just their initial motions, right? As in like the moving party and not responding party. So okay, 1, 2, 3, 4, 5, 6, 7. Looks like 7. Some questions we just don't have the answer to. Andrew Brown, welcome back, is asking, how can a judge honestly think Dr. Russell isn't qualified, but Drew Paul is? And I don't even think that there was ever, again, I didn't follow up pretrial, so I don't know. I can't say. I don't know. I don't know. Was there ever a voir dire of Trooper Paul? Like, was there ever anything done? Was it just like, okay, you can tell? I mean, I would assume so. I just don't know what happened pretrial. Like, did that happen? Did they actually have like a voir dire and like she was like, yep, he's great, he's good to go, or did they just not even did the defense not ask for it or what? Because I don't know. I either way, what is Trooper Paul even doing? Like, he's just needs. I don't even know what the right career for him is, but it's not law enforcement. I would say. Well, but experts was what you have voir dire for. Like that's why you don't do that with a lay witness. I'm talking about the not jury voir dire, by the way, right? I'm talking about the expert witness voir dire. So like all of the ones that we see, they have to be offered as an expert. And then that's why you would ask for voir dire to see if they qualify as an expert or to see if they're, like Dr. Lanigan, right? That's the same thing. One and the same. How many for the defense? Yeah, Heather says she thinks 14. It looks like it. Because they numbered them. Yeah, 14. Yeah. So 7 and 14. So like in other words, because he's being offered as an expert, the defense might, I just don't know because I didn't follow up pre-trial. The defense could have, and maybe did, object to him coming in and offered as an expert. And then potentially they could have had like a voir dire like they've done with other expert witnesses in this trial and in every trial to determine if he qualifies as an expert. I just don't know if any of that happened. It would only happen if the defense objects. Like if the defense didn't ask for anything, if they didn't, file a motion in limine, to preclude his testimony as an expert witness or whatever, if they didn't do anything like that, then the judge would have, and this is true for any case, the judge would have no reason. The judge doesn't assess it, right? That would only happen. That's the whole point of the system, the adversarial system, right? Things only happen when the other side asks, with some exceptions, but for the most part, right? It's like the same with like how objections work in trial, right? If one side doesn't object to something, then the first side just keeps going, right? So, yeah, so I don't know. I would assume they asked. I would assume that they did something, right? because why wouldn't they? But unless maybe they thought, well, he's just so terrible, like we're not going to let him in, right? I mean, that's a strategy that happens. That does happen. Where if one side thinks the other side's expert is just that embarrassing, they just don't stop them. They say, let it in, let him go, right? That it was going to even just make whatever side they're an expert for look even worse. That could have been the strategy they took with Drew Paul. Could have been, because he's a disaster. Does anybody know? Does anyone know if they did have a voir dire for him? But yeah, anyway, if they didn't have a voir dire on Trooper Paul, then Judge Bev would have not been in a position to assess him. Although it still wouldn't have surprised me if that happened and she assessed him and she found him to be an expert. Wouldn't surprise me, sadly. But I can probably see now, I'm like, I can probably do some digging and see if I can find out if they did do that. They did file a motion in limine for Trooper Paul previously. Although, yeah, I don't know, with a disaster like that, you know, I mean, and to a certain extent, it does actually kind of support their theory of the case anyway, right? With like the law enforcement and the third party. So that could be additional, besides him just being a disaster, that could be an additional reason why it might have been a strategy to let him testify and to not object or not, you know, not try to stop that from coming in. And thank God, right? Because it was like some of the most memorable fucking testimony we will ever see in a trial. I mean, that it was an unmatched and will forever be an unmatched disaster on the witness stand. There will never be anything like that unless he testifies again, which he's on the witness list. So fingers crossed for round two. I know, right? That's what I'm saying. He's so much fun to watch. So yeah, we might get another. You know what's really funny is because you know that they will have had him practice or whatever it is he sits there and does, like tries to count 1 + 1, but can't figure it out type of thing. You know that they're going to have been like, okay, you need to prep like 50,000 hours a day. And it's going to be really funny to see if he testifies again, because we will know that however he does, we will know he did his best and put his all into it, and that they all tried to make him better. And then we will be witnessing the result, like with all of the coaching and all of the whatever, you know what I mean? Like practice hard every day, eat your vegetables. Will it make a difference? Time will tell. It's so funny. It looks like I'm getting all these notifications on my phone. It looks like people think that court starts at 9 for Karen Reed. I guess they didn't get the memo. I mean, I don't know. Unless Turtle Boy that was from Turtle Boy. He was like, we're in court at 9. I don't know how long they're going to be in court at 9, but they're in court in a different courtroom, and then Karen Reed starts after that. So, anywho, but yeah, guys, if you missed it, check out the live stream from earlier with the other docs there. But we will be following back up on all this stuff. We'll probably try to get through more of these, but then again, we'll be coming back and hitting the maps hard, hitting the timeline hard, cameras. And we'll be taking, I'm going to make it so you guys can see everything and it's horizontal for like the car and the maps. And then also we're going to definitely reuse the text messages and all that too. So it's a lot. This is a lot. Like even just from what we covered in this today, like is a lot to implement into what we know of this case. And it's just a lot of things basically. Yes, thank you, Heather. Raised issue with 1 + 1 needing 2 = 2. Response is purple as a flavor. Yes, correct. Heather always has the consistency with that one. She made the joke the other night for the first time, and it was amazing. And she's done a really good job of implementing it with the same, like verbatim almost. It's amazing. I don't even know what I said. My brain is really exhausted. I think I might also be dehydrated. I'm sure I said something along those lines though. 100%. My brain is like both exhausted, but also like working really fast, trying to process all this information. But that'll be it for this one, guys. We will be back, like I said, for more later. And for anyone who hasn't joined the Discord, it is awesome. You will love it. You will be glad you did. It'll be the best decision of your life. I'm going to put a link in the chat for that one. Shout out to Iowa. Thank you. I know I need to drink some water. That's another one of the things that makes it difficult with reading all these documents, because it's like, one, it's hard to drink water and easy to forget, and two, you can't read the chat. But I'm going to try to have a sip of water. But yeah, if anyone hasn't joined the Discord, it is awesome. Also, for anyone who hasn't heard yet, we recently have just started brand new Squirrel memberships. So that is available as well. And yeah, that'll be it though, guys. I love y'all. Y'all are the best. And that'll do it. So I'm going to get that outro going if I can remember how to click on things. There we go. All right. I'll see you guys next time. Love y'all.